Chapter 59 Alternative Dispute Resolution in Family Law 1. Introduction. Alternative Dispute Resolution (ADR) is the resolution of disputes by means other than traditional litigation, where a resolution is the result of negotiation between parties through their lawyers or imposed on them by a judge. ADR often helps separated spouses achieve resolution with less bitterness and expense than traditional litigation, a result that will be especially important if they have children. It can also allow for more flexible and individualized resolutions than traditional litigation. While different types of ADR have been in use for years, in family law, ADR generally involves participation in one or more of the following: mediation, arbitration, mediation arbitration, and collaborative law. Each has its own set of advantages, disadvantages, and special considerations too. Mediation 2.1 Definition. Mediation is a method of dispute resolution whereby the parties retain a third-party professional to assist them in reaching an agreement. A more specific definition from Family Mediation Canada is as follows. Family mediation is defined as a cooperative, problem-solving process, in which a qualified and impartial third-party neutral, the mediator, assists mediation participants to resolve their disputes by mutual agreement. The resolution is to be voluntary and based upon sufficient information and advice for each person involved in the dispute. The purpose of mediation is to assist the parties to accept the realities of their respective situations, understand the underlying interests of the opposing party, and try to reach agreement about how to settle outstanding differences. Its overriding goal is to build consensus between litigious or potentially litigious spouses. It is not marriage counseling, nor is it to be used as a tool to pressure a party into, or to debate the wisdom of, reconciliation. The mediator's role is to listen to both parties and try to help them reach their own agreement. Family Mediation Canada's Code of Professional Conduct outlines the following goals of the process. 1. The goal of family mediation is a fair and workable agreement that meets the participants' mutual needs and interests, not a settlement at all costs. 2. The primary responsibility for the resolution of the dispute rests with the participants. At no time should the mediator coerce participants into an agreement or make a substantive decision on their behalf. 3. The mediator's role is that of a facilitator, i.e., to assist the participants to reach an informed and voluntary agreement that meets their mutual needs, interests and concerns, along with those of others affected by the dispute. 4. The mediator has a responsibility to promote the participants' awareness of the interests of others affected by the dispute and by the proposed agreement, and to assist them in considering the separate and individual needs of such other persons. It should be clear from the above that a mediator does not, should not, and cannot impose an agreement, decide an issue, or provide legal advice. A mediator is not an assessor, namely, a person retained to provide observations, opinions, and make recommendations that could be detrimental to one side. At best, a mediator takes two diametrically opposed views and through discussion, questioning, prodding, and often direct challenging of the parties' underlying motives seeks to expose the real interests that lie behind the spouses' positions, thereby helping the spouses create new options for settlement that neither had previously considered and paving the way for an agreement that meets both their needs. The court in McClintock v. Karam described the mediator's role as follows. In order to effectively mediate, the person appointed must engage in a process that has a good deal of informality. Mediative techniques include persuading, arguing, cajoling, and, to some extent, predicting. Mediation is a process to secure agreement. If possible, all of those techniques, as well as others, will come into play in trying to secure agreement. Even if the parties do not reach an agreement, mediation allows for a focused process in which the parties identify the issues and canvass potential solutions. It can provide a form of catharsis, enabling the parties to acknowledge the destructiveness of blaming and the importance of accepting responsibility for their behavior, a situation that can put them in a better mindset for a negotiated settlement with the assistance of their counsel. It can also provide a better understanding of the opponent's case if the matter proceeds to or continues in court. In practice, it is common for lawyers not to be present with their clients when the issues are being mediated, especially where parenting issues are concerned. While the lawyers are usually involved in the selection of the mediator and in deciding whether it will be open or closed, see below. The number of sessions, and how the fees shall be paid. The actual sessions usually occur solely between the parties and the mediator. Clients can and often do report back to their counsel after sessions for guidance and advice. When an agreement is reached, the mediator reports back to the lawyers, preferably in a memorandum of understanding, and the lawyers take over, draft, and revise the separation agreement and ensure each party signs. Because of the lawyer's limited role in the actual mediation sessions, one of the mediator's most crucial responsibilities is to ensure that the parties employ a fair, safe, and balanced process to negotiate their settlement. The mediator should not be in a position of power over the parties, for example, by also being the assessor. Otherwise there would be concerns that the settlement was not a true reflection of the parties' views but rather something imposed by subtle pressure from the mediator. Throughout the process, the mediator must act fairly in structuring the negotiation, maintaining the channels of communication with each party and between them, articulating their needs, identifying the issues in dispute, and making suggestions. A good mediator will keep the lawyers apprised of progress during the mediation. 2.2 Open versus closed mediation. One of the most important considerations for lawyers is whether the mediation should be open or closed. Open mediation means that at the conclusion of the mediation, the mediator files or prepares a full report and is free to include anything relevant to the matter. Evidence of anything said or of any admission or communication made in the course of the sessions is admissible in a proceeding whether the clients consent or not. Closed mediation means that at the conclusion of the mediation, the mediator files or prepares a report that either sets out the agreement reached by the clients or states only that they did not reach agreement on the matter. Here, evidence of anything said or any admission or communication made in the course of the mediation is not admissible in any proceeding except with the consent of both parties. It is extremely important that the lawyer canvass the difference between open and closed mediation with the client before signing the agreement to mediate. Whether mediation is open or closed is a decision to be made by the parties. Usually, the mediator or the lawyers will have a preference that tends to influence the decision. Proponents of open mediation suggest that participants in closed sessions are prone to take unfair advantage of the fact that what is said cannot be revealed in court and are often less motivated to adopt reasonable attitudes and positions. Critics of open mediation, on the other hand, contend that knowing that each and every utterance made in a session might be used in court inhibits the parties from negotiating in a full and frank manner. While neither method is perfect and each has its advantages and disadvantages, mediation cannot be effective unless both sides are open to the process. Spouses who are motivated to mediate in good faith should be equally able to resolve their dispute regardless of whether the mediation is open or closed. While most mediation is closed, clients should be made aware of the differences between the two types before they start the process. Since there is no guarantee that there will be a resolution of their case by this method, lawyers should be aware of the decision in CAMVDM, where the Ontario Court of Appeal refused to admit into evidence reports prepared by a clinical investigator for the Office of the Children's Lawyer where such reports were prepared as part of an attempt at a failed mediation of the appeal. The case is also significant in that it confirms the Court of Appeal's policy to abide by its practice direction for pre-hearing settlement conferences in Family Law Appeals Pilot Project, a pilot mediation project for family law appeals. The policy is that if there is a successful resolution arising from the mediation, the resulting agreement and draft order are disclosed to the panel when the appeal is to be heard. Otherwise, the fact of the settlement conference, the memoranda filed and all deliberations in the process will remain strictly confidential and without prejudice to the parties' legal positions. Rosenberg J.A. held that the appellants proposed fresh evidence consisting of the parties' subsequent involvement with the Office of the Children's Lawyer and the investigators' reports prepared after the trial were not in accordance with the practice direction and should not have been accepted as fresh evidence. To allow such reports to be filed into evidence without the other party waiving the confidentiality and containing without prejudice conditions would be incompatible with and undermine the legitimacy of the without prejudice nature of the settlement conference process. Where parties have agreed to closed mediation, the court cannot compel the mediator to testify. Rudd v. Trossachs Investments Inc. In practice, most of the time, family mediation is closed, although there are benefits of an open mediation. Most notably a judge being able to see favorable comments made by the mediator about the client and the client's case. On the other hand, clients do not know ahead of time what the mediator will write, so there is an equal risk that the mediation memo will have some negative comments the client would rather the court not see. The key is that, like all forms of ADR, the client should not blindly enter into any process without fully discussing the pros and cons with the lawyer. It is the lawyer's job to spend the requisite time with the client, ensuring proper advice is given on which form of ADR is best for the case at that time. 2.3 Optimal conditions. It is important for the lawyer to be able to identify whether the client is a suitable candidate for mediation. While by no means exhaustive, and while the presence or absence of any of these factors does not necessarily predict for or against an eventual outcome that is satisfactory to the parties, in general, the more the conditions listed below are present, the greater the likelihood of a speedy agreement being amicably reached. The parties are emotionally ready, they are evenly matched in terms of bargaining power, they are patient in temperament and flexible in attitude, they are good listeners where parenting issues are concerned, they are child-focused, they do not shy from fulfilling their financial disclosure obligations, they are motivated to reach a negotiated resolution, they trust each other, or if not, they trust the mediator to be the guardian of trust. There are genuine issues to negotiate. There is more than one way to shape or structure a settlement. A critical legal principle or governing regulation is not an issue. The timing and certainty of an early outcome are important to them. They want to control the degree of risk associated with the resolution. They want to craft their own resolution. Cultural factors or considerations exist that would not or perhaps could not be addressed in any other process. A less formal, more caring atmosphere is needed to allow challenged or vulnerable persons to participate. Non-evidentiary issues are as important as, or more important than, technical legal issues. On the other hand, mediation may not be advisable if some or all of the following conditions are present. There is a significant power imbalance between the parties that cannot be accommodated or addressed in a fair mediation process. There is any sign of bullying. There is a history of abuse. One party will not agree to make full and frank financial disclosure. The parties cannot or will not take responsibility for the outcome. One or both parties demonstrate extreme inflexibility on any issue. There is a lack of commitment by one or both parties that manifests itself in a failure to meet deadlines, last-minute cancellations, or general disdain of the process. The presence of one or two of the above-noted factors does not mean mediation cannot take place. However, the more they exist and the more severe each factor is, then the more litigation may be the most practical course of action. Recognizing whether the client is a suitable candidate for mediation is important for several reasons. The lawyer's skills may be called upon in different ways depending on the presence or absence of the above factors. For example, the lawyer with a self-aware, resolution-oriented client will be kept informed by the mediator as to the progress of the sessions and may be consulted from time to time as to the lawyer's suggestions. For the most part, the lawyer with this type of client is in the background until a resolution is achieved. Alternatively, the difficult, impatient, vengeful client will often require more involvement by the lawyer in the process. In these situations, the lawyers and mediator often collaborate more in order to resolve certain issues as they are. I see Risa S. Eisen's article identifying the client for whom mediation is appropriate in family law mediation. How to use it. Whether to do it. 2.4 Mediation and domestic violence. Domestic violence is the intent by a spouse to intimidate, either by threat or use of physical force, the other spouse's person or property. A lawyer advising a client who has been a victim of domestic violence and is now contemplating mediation must proceed cautiously and with full awareness of the client's circumstances. Since the purpose of violence is to control someone's behavior by the inducement of fear, the impact of violence may leave the client in fear of confronting or challenging the former partner even well after separation. This creates a power imbalance that may prevent meaningful negotiations, thus increasing the chance the client will agree to an unjust or impractical settlement. This is particularly so if both parties are in the matrimonial home during the process. An abused spouse living under the same roof as the abusive partner is far more susceptible to intimidation tactics, both emotional and physical, than spouses living in separate residences, and thus lawyers should be confident that mediation is unsuitable for the client when these circumstances exist. Even if the parties have separated and the incidents of domestic violence occurred some time in the past, the emotional effects of the violence may continue to have an impact, and mediation may not be appropriate. If the client already has a lawyer before deciding to mediate, the lawyer plays an integral role in advising the client. The lawyer should ask questions of the client that will hopefully establish whether domestic violence was present in the relationship and, if so, to what extent. The lawyer should inform the client that mediation requires both parties to be open and candid in expressing their views, even if they are strongly opposed by the other spouse, and that domestic violence may impair the client's ability to do so. The lawyer should advise the client not to mediate if there is anything to suggest that the client's ability to negotiate on an equal level with the other spouse is impaired by the history of domestic violence. In most cases of abuse, this will be the case, and mediation will not be appropriate. The lawyer advising a client on the matter may wish to consult with any therapist that the victim of abuse or violence is seeing to help the lawyer advise the client. Also, it is advisable for the lawyer to speak to the mediator if the parties have already begun mediation at the time of the lawyer being retained, since the mediator is likely well trained in the area of domestic violence. If the parties have not yet started mediation at the time the lawyer becomes involved, the lawyer might consider having the client screened by the mediator before advising the client on the pros and cons of mediation. The mediator might rule out mediation or have other suggestions for the lawyer and client's resolution. If the client insists on pursuing mediation despite a history of domestic violence, the mediator should engage in the mediator's own determination at the intake stage as to whether domestic violence was or is present in the relationship and whether mediation is feasible. If the client has not previously seen a lawyer, this may be the first time that questions regarding domestic violence have been posed or answered. The mediator must determine whether the abuse and/or violence renders the client in an unequal bargaining position that would prevent the client from negotiating. Where a client has been identified as having experienced domestic violence and is incapable of negotiating as a result, the mediation should not proceed, and the client should be encouraged to obtain immediate independent legal advice and to consider applying for a restraining order as soon as possible. Where domestic violence has been disclosed and the mediator has determined that the client has not been rendered incapable of negotiating, wants mediation, and has independent legal advice, the mediator may still conduct the mediation in a manner that offers maximum protection for the spouse. For example, the mediator may meet with clients in separate rooms or meet with them together but allow the spouse to have a counselor or friend present along with frequent contact with the parties' separate lawyers. The Ministry of the Attorney General requires arbitrators to have 10 hours of training every 2 years in order to be qualified to practice. Half of these hours must be on domestic violence issues. Since many mediators in the family law arena also work as arbitrators, this is an important component of their continuing training and education. 2.5 The process. Although not all mediators employ the same process, the following constitutes the customary steps in a typical family mediation where both clients already have lawyers. Step number 1. The lawyer discusses all aspects of mediation with the client and advises whether mediation would be feasible or advisable. Step number 2. If the parties agree to attempt mediation, the lawyers make recommendations, and the clients eventually decide on a mediator and the sharing of cost. The decision is reached as to whether the mediation will be open or closed. Step number 3. The mediator is contacted by the lawyers and consulted as to the mediator's availability, and a referral is made. Step number 4. The mediator meets with the lawyers, usually by conference call, obtains the basic details of the case, establishes the terms of the assignment, including payment, and confirms whether the mediation will be open or closed. Step number 5. The clients, and sometimes the lawyers, sign an agreement to mediate. Sometimes the mediator simply sends a confirming letter to the lawyers. Step number 6. The mediator meets the parties separately for an introductory meeting to obtain the basic details of the case, glean their expectations, and assess the viability of mediation, including assessing any domestic violence issues. Step number 7. The mediator conducts one or more meetings with the parties, engaging in problem solving, discussion, and negotiation of the issues. If the parties are mediating financial issues, the mediators often work through the financial statements and discuss disclosure issues with the client. Step number 8. The mediator liaises with counsel throughout the process as necessary, apprising them of the progress or eliciting assistance on an issue. Usually, mediators do not contact the lawyers unless directed to do so by the clients. More commonly, the clients seek the advice of their lawyers from time to time during the process, or the lawyers call the mediator. Step number 9. The mediator assists the parties in reaching an agreement on one or more essential terms. The mediator summarizes the details of the agreement and forwards it to the clients or lawyers for their comment and input. This may be in a letter or basic outline called a memorandum of understanding. Some mediators prefer to draft the entire agreement itself, if not already prepared by the mediator. The lawyers draft the agreement. Step number 10. The lawyers meet with their clients separately and provide independent legal advice. The lawyers exchange comments, copying the mediator as necessary. Step number 11. If necessary, Revisions to the agreement are discussed and, if necessary, mediated and resolved. Step number 12. Final revisions are made, and the agreement is signed by the parties in the presence of their respective lawyers. The process described above is followed generally by privately retained mediators who are not working through the family court mediation centers. The process used by mediators at courthouses that offer mediation is often considerably different, and lawyers should be familiar with the procedure used at court if the parties are contemplating using such a service. 2.6 Lawyer's role. Of utmost importance is the lawyer's responsibility to provide independent legal advice to the client. There is often a tendency on the lawyer's part to refrain from fully advising a client in the context of a mediated settlement as one would in a traditional litigation setting. The tension arises when the lawyer feels the client would be better protected if a particular clause was removed from or added to the memorandum of understanding when the client has already agreed in principle to something different in mediation. The tension is heightened when the client very much wants to minimize legal and mediation costs and just get it over with. In the face of such pressure, the lawyer must be ever mindful of the prime responsibility to advise the client fully of the legal aspects of the proposed agreement. While not an exhaustive list, the following highlights the lawyer's roles and responsibilities in advising a client engaged in the mediation process. Selecting the mediator. The lawyer helps with such decisions as assessing the mediator's qualifications, evaluating their professional experience, checking references, determining costs and method of payment, obtaining availability, finding out any preconceived ideas about custody, and deciding between open and closed mediation. Providing independent legal advice. Participants should understand their rights prior to negotiating the terms of an agreement. If this is done, clients are more likely to reach agreements that are reasonable as well as durable. Preparing the client. The lawyer should ensure the client has a clear understanding of the goals of mediation and the process and understands that the mediator is a facilitator, not a legal advisor, and the rules and goals in mediation differ from the adversarial process. Demonstrating an ability to work in the mediation structure. The mediator may seek out the lawyer's assistance with a particular problem, practical or legal, and the lawyer must be prepared to work with the other lawyer and the mediator to overcome it. Part of this process may involve the lawyers offering their interpretations to the mediator, often a non-lawyer, of certain aspects of the law, demonstrating an ability to know what services to offer. Understanding the dynamics of mediation and helping the client decide whether to enter mediation is key. The lawyer must understand that mediation is not appropriate in every case or for every issue and must avoid agreeing to the process when the lawyer believes it will not work. Providing advice on selecting the mediator. At a minimum, the lawyer should have some knowledge of the person to whom the client is being referred and an appreciation of the person's suitability for the assignment. Most importantly, the lawyer should be actively involved in the selection of the mediator and advising the client not to participate if the client feels the mediator is not right for the case. Avoid interfering with the mediator and the mediation process. Lawyers should deal with matters as they arise and let the mediation run its natural course. They should refrain from becoming emotionally involved with the client, abstain from seeking to preserve control over their client, and exercise restraint so that the adversarial process is not perpetuated. 3. Arbitration and mediation. Arbitration. 3.1 Definition and arbitrator's role. Arbitration is a legal procedure where the parties agree to appoint a person, who becomes the arbitrator, to review the evidence and arguments of the parties and render a decision, called an award, which is binding. In addition to the benefit of being able to select an experienced decision maker, arbitration offers 3 other advantages. First, the parties have the ability to decide which steps they will take: examinations, affidavit of documents, conferences, documents they will exchange, and timelines, whereas in court, no such freedom exists. Second, unlike in traditional litigation, parties to an arbitration can not only choose their hearing date but usually have the hearing much earlier than having to wait for a trial. Third, like mediation, arbitration has the advantage of allowing for private resolution, thus minimizing the risk of exposing the parties and their children to public disclosure of intimate and potentially embarrassing matters. 3.2 Legislative basis. Arbitration Act, 1991. The Arbitration Act, 1991, Act, and the Family Law Act FLA, provide a complete code for arbitrations in Ontario. An arbitrator's jurisdiction is limited by court order or the document signed by the parties in which they agree to arbitrate, now referred to as the Family Arbitration Agreement and previously known as a submission to arbitration. An arbitrator has no inherent jurisdiction. Pursuant to the Act, The arbitrator has the following powers if not circumscribed by the parties or judge: to decide questions of law or refer such questions to court. S8. 2. To rule on its own jurisdiction or on the validity of the act. S17. 1. To make an order for the detention, preservation, or inspection of property. S18. 1. To determine the procedure to be followed during the hearing and to determine when and where it will be conducted, having regard to the parties' convenience and other circumstances of the case. SS20. 1. And 22. 1. To appoint an expert to provide evidence before the arbitrator. S28. 1. To administer an oath or affirmation. S29. 1. To require a witness to testify. S29. 3. To make interim decisions. S41. To dismiss a claim where a party fails to cooperate, or to proceed without the party who is delaying and or not cooperating. SS27. 3. 4. And to award costs including the arbitrator's fees. S54. 1. The intention of the act is to require parties to use the dispute resolution mechanism that they agreed to when they contracted for it. When crafting the terms of an arbitration, lawyers have the ability to participate in a process that is flexible and accommodating to the parties and counsel. This flexibility is subject to SS 19, 1, 2, of the Act, which require the parties to be treated equally and fairly and be given an opportunity to present their case and respond to the other side's case. Under S3, an agreement to arbitrate may not vary or exclude, among other things, these two criteria, which are commonly called the rules of natural justice. The following principles relating to the rules of natural justice apply to the conduct of all arbitration hearings. Terence W. Caskey, Alternative Dispute Resolution Pre-Trial Strategies for Family Lawyers, Creating the Right Foundation for Settlement. Adequate notice of the time and place of the hearing must be given. Each party must be allowed to let evidence and to cross-examine. Each party must be allowed to make submissions and to respond to the other party's submissions. The hearing must be conducted in the presence of both parties. The process must avoid evidentiary surprises for each party. The process must ensure each party knows clearly the case to be met. Each party must be allowed to make submissions if the arbitrator desires to consider evidence that has not been put into the record by either party. Treating the parties equally and fairly includes listening fairly to both sides, giving the parties a fair opportunity to contradict or correct prejudicial statements, not receiving evidence from one party behind the back of the other, and ensuring that the parties know the case they have to meet. An unbiased appearance is, in itself, an essential component of procedural fairness. Hercus v. Hercus 3.3 Amendments to Arbitration Act, 1991. Family Statute Law Amendment Act, 2006. Bill 27. In April 2007, the Family Statute Law Amendment Act, 2006, FSLAA, amended the FLA and the Act with respect to arbitrations. Prior to its passing, Ontario law did not differentiate between family law arbitrations and other types of arbitration under the Act. Parties to an arbitration agreement were not only able to choose the governing law, they could also completely insulate arbitral awards from any kind of appeal in court. In light of the government's desire to ensure that faith-based arbitrations would not be enforceable in Ontario, the FSLAA fundamentally changed the procedure and substance of how family arbitrations are conducted and enforced in this province. By amending the Act and the FLA, the FSLAA created a new regime for Ontario family arbitrations with the following features. The new term family arbitration applies only to processes conducted exclusively in accordance with the law of Ontario or another Canadian jurisdiction. Other third-party decision-making processes in family matters are not considered family arbitrations and will have no legal effect. Act, SS 1, 2.2, and 32, 4, FLA, S 59.2. Both the Act and the FLA now apply to family arbitrations, and the latter will govern in case of a conflict between the two statutes. Act, S 2.1, 2, FLA, S 59.1. Family arbitrations must be conducted pursuant to a family arbitration agreement, which must contain a confirmation of independent legal advice, be signed by both parties, and be witnessed. A mediation arbitration agreement is a family arbitration agreement that provides for mediation before arbitration and, if the mediation fails, the mediator arbitrating the dispute. Family arbitration, made under the Act, O. Reg 134/07, S1. Family arbitration agreements are now classified as domestic contracts under Part IV of the FLA, which means they must comply with S 56, 4, of that legislation. This means a court may, on application, set it aside if a party failed to disclose significant assets and liabilities, if a party did not understand the nature and consequences of the agreement, or otherwise in accordance with the law of contract. FLA. S51A secondary arbitration is where an arbitration is conducted in accordance with a separation agreement, court order, or previous arbitration award that provides for the arbitration of possible future disputes relating to the ongoing management or implementation of the agreement, order, or award. FLA. S59.7. 2. Secondary arbitrations still require a written family arbitration agreement, but it is not necessary for the parties to receive independent legal advice before participating. FLA. S59.7. 1. Two parties to a family arbitration agreement may agree, expressly or by implication, to vary or exclude any provision of the Act except certain procedural requirements, including the right to appeal. Act. S3.2. Arbitration awards will now only be enforceable under the FLA by way of motion or application to the Family Court of the Superior Court of Justice or Superior Court of Justice, as the case may be, on notice to the opposing party, provided the materials set out in the FLA are filed and the criteria fulfilled. The court shall make an order pursuant to its terms. FLA. S59.8. Act. S50.1. Power is provided to make regulations to require arbitrators to be members of a specified dispute resolution organization, undergo training, submit reports, keep records, and inquire into matters such as power imbalances and domestic violence. Act. S58. Family arbitration requires every mediation arbitration agreement made on or after September 1, 2007, to contain clauses confirming the arbitration will be conducted in accordance with Ontario law and detailing the routes of appeal from an award, as well as a certificate signed by the arbitrator confirming that the arbitrator will treat the parties fairly and equally. The arbitrator has received the appropriate training approved by the Attorney General, and the parties were screened for power imbalances and domestic violence. S2. The regulation also, for the first time, requires arbitrators to receive training approved by the Attorney General, keep a record of the arbitration, and file a report about the award to the government. SS3-5. For sound policy reasons, family law permits and encourages separating parties to work out their own agreements through separation agreements that include how to resolve future disputes, where parties are both represented by experienced family law counsel at the time they enter into a comprehensive separation agreement that provides for a contractual obligation to mediation arbitration. Unless there are some exceptional circumstances, the parties should be required to abide by that agreement. Thompson v. Thompson 3.4. The processes in mediation. There is no one correct way of setting up an arbitration. The following, however, is an outline of how a common family law arbitration usually proceeds, with mediation as a precursor. Step number 1. The lawyers discuss the feasibility of arbitration with their clients. Step number 2. The lawyers propose and agree upon an arbitrator and, ideally, the sharing of costs. Step number 3. The lawyers have a conference call with the arbitrator. In the call, the major issues are discussed, a date is set for the mediation, and the briefs and agreements on retainers and disclosure are delivered. They also discuss and agree on how the domestic violence screening will be done, who will do it, and the timelines for getting it done prior to the agreement being signed. Step number 4. The arbitrator prepares and sends to counsel a draft family arbitration agreement that contains a list of the issues to be decided, the name of the arbitrator, the time and place of the mediation or arbitration, information on the procedure to be employed, a waiver of the arbitrator's liability, the rights of appeal, and details of the arbitrator's fees. Step number 5. The lawyers exchange mediation briefs and file a copy with the arbitrator. Step number 6. The lawyers and clients meet with the arbitrator for mediation. By this time, the parties have been screened for domestic violence, either by the arbitrator or by a third person mutually agreed to by counsel and the arbitrator. The arbitrator ensures the family arbitration agreement has been signed, the parties have been screened for domestic violence issues, and the arbitrator's certificate has been signed. Step number 7. The parties spend a day or half-day with the arbitrator trying to mediate the issues in dispute. The mediation can be extended to another day if the parties agree or the arbitrator feels the dispute can be resolved. Step number 8. If a settlement is reached, the arbitrator will prepare a memorandum of understanding, or the parties will sign minutes of settlement or a separation agreement. If no settlement is reached, The lawyers set up a date to discuss how the arbitration will unfold. Step number 9. After a few calls and/or meeting, the format of the arbitration is set. The format of an arbitration can range from a written decision made after the parties submit a brief to a full-blown hearing, identical to a trial. Step number 10. The arbitrator prepares and releases the award with reasons. Step number 11. The arbitrator files the report with the government for statistical purposes. It is increasingly rare to have a case involving arbitration without a prior mediation session. However, those cases do still exist, such as when a client hires a lawyer for an arbitration concerning the implementation of one aspect of a custody and access agreement. The arbitration proceeds in the same way as above minus the steps relating to mediation. It is important for counsel to understand that requiring a formal mediation arbitration agreement, complete with domestic violence screening, rights of appeal, and independent legal advice is not merely suggested or recommended as best practices. It is mandatory. Without it, no arbitral award is enforceable. Horowitz v. Nightingale. 3.5 Preparing for the arbitration hearing. Other than preparing for and presenting the actual case during the arbitral hearing, the lawyer must devote significant time and attention to preparation. Well-prepared counsel and arbitrators canvass all of the important issues in advance, typically during a few conference calls. During these calls, they work out the precise manner in which the hearing will proceed, failing which the arbitrator can make an award on procedural matters, including the following: identification of the parties. Who is the applicant? Who is the respondent? Who will go first in terms of presenting evidence? Definition of the issues, if not already contained in the arbitration agreement or court order. What issues will the arbitrator decide? Details of hearing. Principally, these are the exact time, date, and location of the hearing. Pleadings. If litigation has commenced, are the pleadings sufficient? If not, the arbitrator may require the parties to submit a statement on the points in issue, their position on each, and the relief sought. Any documents relevant to the statement may be attached. Failure to ensure proper pleadings have been exchanged may result in the arbitration award being set aside. Pedersue v. Pedersue. Financial statements. Net family property statements. Are the existing statements sufficient or are fresh statements required? If so, timelines for their exchange should be established. Disclosure. Is additional disclosure required? If so, timelines for its exchange should be established. Sanctions for noncompliance. How will the arbitrator deal with a party who does not comply with timelines or is uncooperative in some other manner? Temporary proceedings. Is there a need for a temporary step or order to be conducted or made before the main hearing? Witnesses. Who will the witnesses be? What will the timelines be for the exchange of witness statements? And will a summons to witness be required for any of them? Additionally, will their evidence be under oath, other affirmation, or not expert evidence? Has any expert evidence been obtained? Should a joint or third-party expert be retained? Settlement meeting. Should a settlement meeting be held prior to the hearing? And if so, will it be conducted by the arbitrator or another person unfamiliar with the case? Recording evidence. The parties should canvass whether a court reporter will be required so that a transcript can be prepared in the event of an appeal. It is recommended that if there is going to be oral, viva voce, evidence, the parties have a reporter present. Format of evidence. Who will go first, and when will the arbitrator be able to ask questions? The common practice is that the arbitrator allows the evidence in chief, the cross-examination, and reply all to be completed before asking any questions, and then allows each party to ask any questions that arise out of the arbitrator's questions. Often, in order to save time and expense, the parties will agree ahead of time on filing each side's examination in chief by affidavit and then having cross-examination take place during the hearing. Rules of procedure and evidence. Are there any evidentiary issues that the arbitrator or either party foresees as problematic? Does any party require the use of visual aids or the ability to testify remotely through Skype or other means due to an inability to attend in person? Are the parties agreeing in advance that certain types of hearsay evidence will be admissible? The arbitrator will then commit everything that was agreed upon to writing and send a copy to counsel. Any errors or clarifications should be immediately brought to the opposing side's attention. If all of the above are sufficiently completed, the parties, counsel, and arbitrator will benefit from a well-organized and efficient arbitration. 3.6 Mediation Arbitration. The two-step process described above, whereby the parties retain one person to assist them in reaching a negotiated agreement, failing which they confer on that person the right to make a binding decision, is a popular variation on the strict arbitration model and known as mediation arbitration, or more commonly MEDARB. The mediation arbitration process has advantages and disadvantages. Like pure mediation, the process is private, confidential, and offers parties the option of selecting an experienced person to help them reach an agreement in a setting and manner entirely of their own choosing. The arbitration component is designed to allow for a relatively quick and final decision to be made by the same person in the event an agreement is not achieved, thus saving time and, hopefully, money. Proponents also assert that since at the end of the mediation the parties usually know the mediator's stance on an outstanding issue, it is more likely they will save themselves the time and expense of a hearing and promptly settle. Critics point out that mediation and arbitration by the same person is inherently incompatible because while an arbitrator is required by the Act to act fairly and impartially, a mediator's job is to encourage settlement, which may or may not be consistent with the parties' rights under the law. They argue that when negotiating the issues, the parties will inevitably have their eye towards what the mediator thinks and believes in order to persuade the mediator to a particular point of view owing to the fact that at the end of the day the decision will not be theirs to make. An additional critique is that the mediator may glean information from one side during a caucus that may not be shared with the other side. If the mediation is not successful and the case is arbitrated, there is a risk the arbitrator may rely on that information in reaching a decision. Proponents of the process counter that in this regard, the arbitrators are bound to make an award based solely on the evidence presented and are not unlike a judge in a voir dire who is trained to exclude that which was heard during the voir dire. Counsel who proceed with mediation arbitration must be aware of S35 of the Act, which specifically prohibits arbitrators from conducting any part of the arbitration as a mediation or conciliation process. This provision can be waived in the Arbitration Agreement 3.7 Rights of Appeal, Judicial Review Applications, and Standard of Review in general. The language of the Act and case law are clear that the courts have a limited ability to intervene where parties have made the mutual decision in a contract to settle their disputes through arbitration. The Act entrenches the primacy of arbitration proceedings over judicial proceedings, once the parties have entered into an arbitration agreement, by directing the court generally not to intervene. See Grossman v. Cookson. Notwithstanding parties' ability to contract out of the legislation in favor of private arbitration, there are some limits. The Act provides that any provision in a family arbitration agreement that purports to exclude or vary S45 of the Act is of no force and effect. S3. 2. V. Section 45 provides as follows. 45. 1. If the arbitration agreement does not deal with appeals on questions of law, a party may appeal an award to the court on a question of law with leave, which the court shall grant only if it is satisfied that the importance to the parties of the matters at stake in the arbitration justifies an appeal, and b. determination of the question of law at issue will significantly affect the rights of the parties. 2. If the arbitration agreement so provides, a party may appeal an award to the court on a question of law. 3. If the arbitration agreement so provides, a party may appeal an award to the court on a question of fact or on a question of mixed fact and law. 4. The court may require the arbitral tribunal to explain any matter. 5. The court may confirm, vary or set aside the award or may remit the award to the arbitral tribunal with the court's opinion on the question of law, in the case of an appeal on a question of law, and give directions about the conduct of the arbitration. 6. Any appeal of a family arbitration award lies to the family court, in the areas where it has jurisdiction under Subsection 21.1. 4. Of the Courts of Justice Act. B. The Superior Court of Justice, in the rest of Ontario. For clarity, the Act thus permits parties to tailor their routes of appeal with respect to the following: a question of law pursuant to S45. 2. A question of fact alone, or a question of mixed fact and law pursuant to S45. 3. An appeal of a finding of fact by an arbitrator can only succeed where the arbitrator has committed a palpable and overriding error, or has made findings of fact or drawn inferences which are clearly wrong. Regarding questions of law, the standard is correctness. If the judge used the wrong test, the arbitral award should be overturned. A question of mixed fact and law deals with the application of a legal standard to a set of facts. Findings of mixed fact and law lie along a spectrum and leave the appeal court with more latitude. If the error can be attributed to the application of an incorrect legal principle, then the standard is correctness. If the legal principle, however, cannot be extricated from the facts, then the question is subject to a standard of palpable and overriding error. unless it is clear that the trier made some extricable error in principle with respect to the characterization of the standard or its application, in which case, the error may amount to an error of law. Patent Cass v. Cass. The Act invalidates waiver of the right to appeal so that there will be a right of appeal with leave pursuant to S45. 1. If the agreement is silent on the right of appeal, or if for some reason there is no agreement, e.g., the parties attended arbitration as a result of a consent order made in court. In addition to appeal rights, a party may also apply to have an award set aside on any one of the following judicial review grounds, all of which are enumerated in S46 of the Act. 1. A party entered into the arbitration agreement while under a legal incapacity. 2. The arbitration agreement is invalid or has ceased to exist. 3. The award deals with a dispute that the arbitration agreement does not cover or contains a decision on a matter that is beyond the scope of the agreement. 4. The composition of the tribunal was not in accordance with the arbitration agreement, or, if the agreement did not deal with that matter, was not in accordance with the Act. 5. The subject matter of the dispute is not capable of being the subject of arbitration under Ontario law. 6. The applicant was not treated equally and fairly, was not given an opportunity to present a case or to respond to another party's case, or was not given proper notice of the arbitration or of the appointment of an arbitrator. 7. The procedures followed in the arbitration did not comply with the Act. 8. The arbitrator committed a corrupt or fraudulent act, or there is a reasonable apprehension of bias. 9. The award was obtained by fraud. 10. The award is a family arbitration award that is not enforceable under the FLA. There have been only a few reported cases where an arbitrator's award made in a family law case was set aside pursuant to S46. 6. In Duguay v. Thompson Duguay, the parties had previously entered into an agreement in which they agreed to arbitrate any access disputes. The agreement also provided the father would pay child support of $600 per month. The father submitted the issue of access transfer arrangements to arbitration. The arbitration was conducted by a social worker. It began with open mediation and ended with arbitration after no agreement was reached. The mother refused to take part in the arbitration because she lost confidence in the social worker's impartiality and fairness. The arbitration went ahead, and an award was made in favor of the father. The mother refused to follow the award, and the father brought an application to enforce it. The mother then brought an application to set the award aside and change the settlement agreement provisions for access and child support. Perkins J. ruled in favor of the mother. He found that the arbitrator appeared to compromise his ability to decide impartially by proceeding in the mother's absence, and that it was incumbent on the arbitrator to help the parties reach a new agreement before proceeding to arbitrate, even though the parties agreed to, but did not sign, a dispute resolution agreement drafted by the mediator arbitrator that stated that the mediator arbitrator would determine when the mediation had concluded, and that the fact that the mediator arbitrator had mediated could not serve as the basis for a challenge to the arbitration. The court found that the arbitrator should not have proceeded to arbitrate absent express agreement from both parties. A similar decision was reached in Hercus v. Hercus. Although there were clear findings in that case that the mediator arbitrator failed to treat the mother fairly and equally as required in S6 of the Act by not giving her sufficient notice and requiring her to state her position on certain issues, before informing her of the father's proposed changes to the parenting plan. Nonetheless, Templeton J. agreed with Perkins J.'s reasoning in Duguay in finding that where the mediator arbitrator declares the mediation at an end, it is incumbent on the mediator arbitrator to reach a new agreement between the parties. To many, both decisions seem at odds with the fundamental essence of mediation arbitration, for they seem to suggest that one party can avoid the arbitration portion of the mediation arbitration by simply withdrawing before it begins. Commentators have voiced their concern about the practical impact of requiring parties to sign a new agreement on appointing an arbitrator when one of them has lost confidence in that person to arbitrate. Others have sought to explain the decision by pointing to the fact that in Duguay, the parties did not sign the dispute resolution agreement, and observing that the social worker's position, it was the same arbitrator in both Duguay and Hercus, was not represented before the court. Nonetheless, most troubling is that the court's obiter in Duguay, which is followed in Hercus and suggests that the Act's enforcement clauses are not framed particularly for family law, especially not for custody and access matters. This has left many with the impression that arbitral awards are not as final in custody and access cases as in other kinds of cases. In Kynes v. Potter, the court set aside an arbitrator's access award because he allowed unchecked and unjustifiably interventionist conduct by the husband and his lawyer during the hearing, which resulted in the unrepresented wife not being treated fairly or equally. The procedural and evidentiary flaws committed by the non-lawyer arbitrator were so flagrant and manifest as to deny the wife equality and fairness. In admonishing the arbitrator's conduct, which essentially allowed the husband and his lawyer to run the show at the hearing, the court offered the following guidance for dealing with self-represented parties. Represented parties are entitled to receive assistance from an adjudicator to permit them to fairly present their case on the issues in question. This may include directions on procedure, the nature of the evidence that can be presented, the calling of witnesses, the form of questioning, requests for adjournments, and even the raising of substantive and evidentiary issues. In McClintock v. Karam, the court ordered that the arbitrator be replaced because during a recorded mediation he was heard warning the mother she was going to lose custody because of her alienating behavior and then fixing a date for a hearing without her or her lawyer's input on dates. The arbitrator then insisted the hearing proceed even though her lawyer had a vacation pre-planned on the hearing date. The court found there was a reasonable apprehension of bias and said that while mediators are permitted to cajole, persuade, and use other methods designed to get parties to agree, they must always treat the parties fairly and be open to persuasion. In Riley v. Zacharuk, the court said that in order to establish a reasonable apprehension of bias, the applicant must show that an informed person, viewing the matter realistically and practically and having thought the matter through, would conclude that the arbitrator would not decide the matter fairly. 3.8 Parenting coordination and mediation arbitration. In recent years, parties have increasingly turned to using parenting coordinators (PCs) to resolve any issues that arise from disputes involving their already signed separation agreements from mediation arbitration. It can be cost-effective and is increasingly popular as a way to help keep families from returning to the court system. As the court noted in Jarova v. Benincasa, parenting coordination is one of the most recent dispute resolution models to enter the Ontario family law realm, although it has been known and used for many years in other jurisdictions. Parenting coordination is used exclusively to deal with parenting issues, and is only possible once a final parenting agreement or court order is in place. To confirm the PC's authority to work with the parents outside of the adversarial process, to obtain information and to make recommendations and decisions as authorized by a parenting agreement. The parent's consent to defer to parenting coordination is normally incorporated into a formal court order. One of the main functions of the PC is to help parents implement the parenting terms of their final agreement court order. As with any mediation arbitration, when adapted to parenting coordination, the process may be divided as follows: the non-decision-making component and the decision-making component. During the non-decision-making component of the process, the mediation phase, the PC assesses the family dynamics to obtain a better understanding of the parenting issues and challenges, educates the parties about child development matters and the impact of parenting conflict on the children, coaches them regarding communication skills and parenting strategies, and mediates disputes as they arise. During the decision-making portion of the process, the arbitration phase, which is triggered when resolution through mediation is not possible, the PC makes a binding decision on the issue in dispute after having provided both parents with an opportunity to be heard. During both phases of the process, the PC is generally given expanded investigative powers to assist in the PC's mandate to mediate or adjudicate on the issue, such as the ability to speak with professionals involved with the family as well as the ability to interview the children, when the PC deems it necessary and it is in the children's best interest to do so. Jarova v. Benincasa. For more information about parenting coordination, see Parenting Coordination. Below 3.9 Enforcement of Arbitral Award effective January 1, 2013. There is a codified procedure for enforcing family law arbitral awards. In the new R32.1 and amendments to R14 under the family law rules, a party seeking enforcement of a family arbitration award must file a request to enforce a family arbitration award. Form 32.1. The request must be in the form of an application under R8. However, if there is already a case in place, the party seeking enforcement need only file a motion instead of a fresh application. RR 32.1. 1. 2. The party seeking enforcement must also file copies of the certificates of independent legal advice for the parties to the family arbitration agreement. A copy of the family arbitration agreement, and the original or a certified copy of the award. R32.1. 1. No financial statement need be filed if the only claim is a claim relating to the arbitration. R13. 1.4. A party seeking to oppose a request to enforce an award must serve a dispute of request for enforcement Form 32.1a on the other party and file it no later than 30 days after being served with the request. 60 days if the request is served outside Canada or the United States. R32.1. 7. Once the documents have been filed, the clerk shall set a hearing date, and the request shall be dealt with on the basis of written documents without the parties or counsel needing to come to court. R32.1. 8. However, the respondent may request an oral hearing by filing a Form 14b motion within 7 days after being served, and the court may order an oral hearing, on a motion or on its own initiative, if it is satisfied that same is necessary to deal with the case justly. R32.1. 9. 10. The conditions for enforceability of a family arbitration award are set out in S59.6. 1. Of the FLA and remain unchanged by the new rules. The family arbitration agreement must be in writing. Each of the parties to the agreement must have received independent legal advice. The requirements of S38 of the Act must have been met. Formal requirements, in writing, reasons, and delivery to parties. The arbitrator must have complied with all regulations made under the Act. If the family arbitration award satisfies the conditions in S59.6. 1. The court is required to make an order in the same terms as the award unless the period for commencing an appeal or an application to set the award aside has not yet elapsed. There is a pending appeal, application to set the award aside, or application for a declaration of invalidity, or the award has been set aside or the arbitration is the subject of a declaration of invalidity. 3.10 Conclusion The mediation arbitration process has advantages and disadvantages of which lawyers need to be keenly aware. Like regular mediation, the process is private, confidential, and offers parties the option of selecting an experienced person to help them reach an agreement in a setting and manner entirely of their own choosing. The arbitration component, however, is designed to allow for a relatively quick and final decision to be made by the same person in the event an agreement is not achieved, thus saving time and, hopefully, money. Lawyers need to be very clear and careful when drafting ADR clauses in their separation agreements. Finally, lawyers should only use a very experienced mediator arbitrator who requires the parties to sign a mediation arbitration agreement for. Collaborative family law 4.1 Definition Collaborative family law CFL can be most easily described as a way of practicing law where the lawyers for both clients agree to assist them in resolving conflict using cooperative strategies rather than adversarial techniques and litigation. Above all, the commitment to work collaboratively is reflected in an agreement between both lawyers and their respective clients that stipulates that should settlement fail, the lawyers will withdraw and not participate in litigation. A comprehensive Ontario-crafted definition is as follows. Collaborative family law is a dispute resolution process in which the parties and their lawyers commit themselves to the realization of a negotiated outcome. They agree that litigation will not be commenced while they are negotiating and that, in the event they are unable to negotiate a resolution of their dispute, neither lawyer will be eligible to represent his or her client in any subsequent litigation. In the process itself, the participants communicate to promote the maximum exchange of information, to reveal all concerns of the parties, to generate an array of creative ideas, and, ultimately, to agree upon the terms and conditions of a mutually acceptable settlement that satisfies the interests of both parties. CFL is not mediation. In mediation, the neutrality of the mediator is an essential element. A CFL lawyer is not neutral. The lawyer not only provides advice, but is an educator, legal resource, and watchdog for the client, as well as guardian of the integrity of the process. 4.2 Key Principles and Process Goals. The principles and process goals of CFL present markedly different ways of practicing family law. Proactive participation. The clients are responsible for and intimately involved in the resolution of their separation issues, as opposed to counsel fiercely advocating on behalf of clients. Clients in CFL voluntarily work with their lawyers to understand the legal consequences of their separation for themselves, the other party, and their family interest. Based understanding. Unlike the adversarial process, the CFL model promotes understanding of the other person's interests and concerns, the rationale being that when parties understand each other, trust is fostered and hostility thereby reduced. The underlying principle is that when each person fully acknowledges what is important to the other, tries to understand the other, and is understood by the other, creative solutions often result. Cooperative resolution. The clients and the lawyers all commit to a cooperative resolution to ensure an enduring agreement. A key component is they agree that litigation is not an option for resolution. Instead, participants strive for common ground instead of focusing on differences. Negotiations are resolved by problem-solving and cooperative strategies rather than adversarial techniques. The clients and lawyers encourage each other to think outside the box and create solutions that, although at times may be beyond the law, maximize solutions for both sides. Multidisciplinary team effort. Central to CFL is the idea that clients and their lawyers work as a team. The team may also include neutral experts for any issue that requires specific expertise, e.g., child specialists, coaches, mental health professionals, or financial specialists. Counselors. The lawyers work with these individuals, modeling an atmosphere of cooperation and respect that allows the clients to gain from their knowledge, skills, and resources and helps them solve complicated issues. The agreement by all parties that the lawyer's retainer is limited to settlement negotiations and that neither lawyer may represent either party in court is crucial to the commitment that both clients and their counsel are strongly motivated to reach a settlement. The theory is that once the option of litigation has been removed, counsel are free from noting how a particular document can be used at trial or how a client would fare as a witness, thus liberating the lawyer to focus on the goal at hand. The phenomenon has been described by one CFL expert as follows: if the lawyers can still consider unilateral resort to the courts as a fallback option, their thought process does not become transformed. Their creativity is actually crippled by the availability of ordered conventional trials. Only when everyone knows that it is up to the four of them and only the four of them to think their way to a solution, or else the process fails and the lawyers are out of the picture, does the special hyper-creativity of the collaborative law process get triggered. At the moment when each person realizes that solving both clients' problems is the responsibility of all four participants, that is the moment when the magic can happen. 1. Good faith negotiations. The most important feature of the CFL lawyer's code of conduct is the requirement of utmost personal integrity and to negotiate at all times in good faith. Specifically, each side agrees to the following: neither will take advantage of the other's mistakes, neither will threaten the other, neither will insult the other, nor dwell on the negative aspects of the other's character. Each will make full disclosure of financial and other relevant information, neither will intentionally delay the process in order to obtain some perceived benefit. Each will encourage the highest good faith problem-solving behavior in themselves and in the other side. Each will behave with and demand the highest integrity from themselves and the other side. The lawyer must withdraw in the event the lawyer's client withholds pertinent information, financial or otherwise, or persistently demonstrates bad faith in the process. Bad faith behavior includes refusals to provide full disclosure, unreasonable delays, breach of any temporary agreements, unilateral action to the detriment of the other party, persistent disrespect toward the other participants, and withholding of necessary funds to a dependent party required to meet living expenses or to pay legal fees during the process. Such behavior should automatically warrant the lawyer's withdrawal from and termination of the CFL process. It is not surprising that many cases are not well suited for CFL. Lawyers should be very careful about pushing a client into CFL where the circumstances strongly indicate that good faith and full disclosure will not be honored. Lawyers should know that not every CFL case leads to resolution, and for those parties, a duplication of legal fees and time will inevitably ensue. 4.3 The participation agreement. Before the negotiations begin, the principles discussed above must be reduced to writing and signed by both clients and their lawyers in a document called a participation agreement. This document is important because it sets out the steps in simple language along with a list of the commitments made. The lawyer will usually give a copy of the participation agreement to the client when CFL is first discussed and review it again before the process begins and at the outset of the first settlement meeting. It is always signed by both clients and their lawyers and may be attached to the separation agreement to confirm the ground rules utilized in reaching agreement. Generally, it contains the following provisions. The clients and lawyers agree to settle the outstanding issues in a non-adversarial manner using interest-based negotiation. The clients will rely on their lawyers to assist them in reaching a mutually agreeable settlement. The clients and lawyers will act in the children's best interests to promote a positive caring relationship between the children and both parents, and use their best efforts to minimize any emotional damage to the children as a result of the separation, including refraining from discussing separation issues in their presence unless both parties agree. All written and oral communications between the participants during the settlement meetings and elsewhere will be respectful and constructive, and neither will take advantage of any errors made by the other. Full and voluntary disclosure will be made throughout. Any neutral experts will be retained if needed. Any temporary agreements will be reduced to writing and executed, which may then be converted into court orders in the event of withdrawal from or termination of the CFL process. The grounds and procedures for withdrawing from or terminating the CFL process will be as agreed to. Neither client will incur any debts or liabilities for which the other may be held responsible. The parties will maintain the status quo on issues relating to children, e.g., their ordinary residence will not be changed, nor will they be removed from the province, and neither will dispose of any assets, alter their life or health insurance coverage, or make any other unilateral change during the process without the consent of the other. Sometimes, for various reasons, after the participation agreement is signed, the parties may wish for some aspect of the case to be admissible in court. Often this involves the work of a jointly retained expert on financial matters, rather than retaining a new expert if the case is not resolved in CFL. Often the better approach is to agree that the expert's report is admissible in court. In order to ensure this is properly documented, the best practice requires an amended participation agreement to reflect these terms. 4.4 The process lawyers who practice CFL are strongly committed to creating a safe process that does no further harm to separating families. The CFL process moves by carefully managed four-way meetings, preceded by considerable groundwork between lawyer and client and between lawyer and lawyer. The lawyer's job is demanding. In addition to the usual identification, investigation, and development of issues and proposals for settlement, they must work with the client and the other lawyer to anticipate and manage conflict and guide the negotiation process. At the same time, while ensuring the client is aware of their legal rights and obligations, the lawyer must also encourage the client to take a considered and broad view in setting goals and priorities, and must teach the client how to use interest-based, rather than positional, bargaining. Before any negotiating session, the lawyers usually meet and share information that will assist them both in managing conflict and in setting the agendas for the four-way meetings. The skill here is to manage agendas in such a way that the clients experience success during the early meetings, thereby building in the clients a sense of confidence, safety, and competency that will serve them as more difficult issues are tackled. One central difference between four-way meetings in CFL and those in traditional four-way meetings is the dominant role the clients play in the former, as opposed to traditional negotiations where the clients offer little input and the discussion is largely driven by the lawyers. In CFL, the clients are the prime authors of the shape and direction of the meeting. The lawyers, while still the legal advisors to the clients, can be more aptly described as negotiation exemplars as opposed to actual negotiators. And further, when they do negotiate, they stop short of taking control away from the clients. A second difference is that unlike traditional four-way meetings, in CFL the lawyer is expected and even encouraged to discuss the issues directly with the opposing client. While this often strikes the uninitiated lawyer as something to resist, its success is pivotal to the creation of a smooth flow of communication between both clients and lawyers and to the full use of the dynamics of four-way communication. Lawyers have found the following 6 steps helpful in finalizing a separation agreement negotiated through CFL. Step number 1. Consulting with the client for the first time. The lawyer listens to the client's concerns, reviews the process options, talks about the client's goals, screens for potential barriers, e.g., safety issues, mental health concerns, abuse, and substance abuse, explains the law as one option, signs the CFL retainer, provides copy of the draft participation agreement, and provides the client with resources for information on CFL. Step number 2. Contacting the other CFL lawyer for the first time. The lawyers meet, either by phone or in person, to begin the team approach to collaborative problem solving, identify any immediate concerns, agree to exchange disclosure necessary to solve the immediate issues, discuss what will happen at the first settlement meeting, confirm which participation agreement will be used and who will prepare it, and set the date and place for the first settlement meeting. Step number 3. Preparing the client for the first collaborative meeting. The lawyer explains the tasks and roles of lawyers and clients, teaches the client appropriate communication and negotiation skills, reviews the protocol and ground rules for settlement meetings, discovers the client's interests, and helps prioritize the interests. The lawyer also explains the client's legal rights and obligations as one of many settlement options. Step number 4. Attending the first collaborative meeting. The clients and lawyers are introduced. The key aspects of the participation agreement are reviewed, and it is confirmed who will record the minutes. The clients deal with any immediate substantive and procedural concerns, and their objectives, interests, and concerns are addressed. Decisions may be made as to what financial disclosure is to be shared and the timeframes for its exchange. Issues are prioritized, and the date and place of the next meeting are set. After the meeting, the lawyers debrief with their clients and each other. Step number 5. Continuing the process toward agreement. Further meetings are arranged and conducted to resolve all issues on the agenda. Homework is assigned between sessions and reviewed at the next session. All required information is exchanged. Neutral experts are retained if necessary. Draft outline agreements are sometimes prepared to move the process forward. Impasses are dealt with, either by negotiation, expert opinion, mediation, or arbitration. Notes of meetings are exchanged, and the process is continued until all issues have been resolved. Step number 6. Documenting and signing the separation agreement. The lawyers jointly prepare the separation agreement collaboratively using language chosen by the clients wherever possible. They ensure the agreement addresses the client's identified needs, ensuring it will work in practice and be legally enforceable. 4.5 Lawyers' roles and responsibilities. An important element of CFL is that the lawyers commit to manage conflict, emotional issues, and relationship issues creatively. To do so effectively, the lawyer needs a whole new array of understandings and skills, and needs to learn to work with non-lawyer professionals. Without this new toolbox, the lawyer runs the risk of promising more than can be delivered and disappointing clients. The retooling needed to become excellent at collaborative law can be described in 4 stages. Retooling how one thinks, speaks, and behaves. Retooling how one relates to the client. Retooling how one relates to the other lawyer, the other party, and other professionals. And retooling how one conducts settlement meetings. This retooling requires ongoing professional training and often involves dramatic changes in how lawyers typically interact with one another and manage their files. Increasingly, special CFL training programs are available for lawyers who want to be able to deal with some or all of their cases this way. Above all, lawyers involved in CFL should do the following: advise their respective clients of the law that applies to their circumstances. The process of giving legal advice, analyzing legal problems, and suggesting solutions serves the purpose of collaborative practice as well, but is carried out in a different context, namely, by the way negotiations are conducted. Model honesty, mutual respect, and dignified behavior guide clients through a process of cooperative conflict by using disagreement as a way to find creative solutions to problems. Get to know their own client as well as the other client, and establish a rapport with both. Model listening skills for each party so that the interests of both are promoted, and in so doing, represent the client's interests while mediating the other party's interests as well. Help identify the issues and concerns of each party. Bring stability and reason to emotionally charged situations, and serve as agents of reality for unreasonable clients. Cooperate fully with each other to provide all necessary disclosure and discovery. Assist the client in organizing disclosure documentation and in understanding the disclosure from the other spouse. Assist the parties to analyze consequences of possible choices and competing values. This includes coaching the client in debriefing meetings, working with them to understand any barriers they may be experiencing, and referring them to outside resources that can assist them to move forward in the process. Respect choices made by a client even if different from what the law may provide or offer. Use clear and neutral language when drafting and speaking. Understand that court is not an option, and refrain from using adversarial techniques or tactics. Remain committed to finding effective ways to assist the parties in reaching agreement and overcoming impasses by using mediation or neutral experts to provide a third opinion. 4.6 Advantages and disadvantages. Lawyers should assess each situation and provide each client with information about all the processes available to resolve their issues. CFL is not for every client or for all situations. Some clients want others to make their decisions for them. Others choose to expend their financial resources and energy to use the courts to achieve their goals. There are also clients who do not want to compromise and are stuck in the traditional win-lose mindset. There are also clients who maintain that their spouses are not trustworthy and are therefore determined to hide assets and income at any cost. Others suffer from clinical issues or serious drug and alcohol abuse. In these situations, CFL may not be appropriate. and traditional litigation, with all the rules and court sanctions, may be recommended to ensure the client's rights are better protected. Lawyers must determine whether a prospective client has or can develop the capacity to participate effectively in the CFL process. Clients must share a similar, if not mutual, commitment to work with rather than against each other. They must demonstrate an acceptance of their separation, a willingness to manage or at least try to learn to manage their emotions, an interest in the well-being of the other side, and a commitment to an honorable divorce process. They must value the benefits of maintaining their relationship, taking a long-term view of the issues, and retaining control over their own solutions. Clients must also understand that, although designed to be successful, not every collaborative effort produces a settlement, and that the time and expense that would be required to rehire a new lawyer and take the matter to court must be considered. For those clients truly committed to open and honest negotiation, full and frank financial disclosure, and flexible and creative problem solving, CFL is becoming, for many, the choice method of dispute resolution in the 21st century. The upsides are obvious: a negotiated agreement reached with less cost and none of the traditional conflict, lawyers for both clients working in an atmosphere of respect and cordiality, and the absence of the stress and uncertainty of litigation. Clients also have the benefit of confidentiality in that anything said in a CFL negotiated session cannot be disclosed without the consent of both parties. In this sense, CFL resembles closed mediation in that it provides the parties with the freedom to openly discuss options they may not otherwise be prepared to voice, with a lawyer by their side at all times. Finally, while critics would say that clients should never waive their right to litigate, clients should be reminded that participation in CFL does not mean that clients forfeit their right to go to court, only to do so using their CFL lawyer. 5. Parenting coordination. Usually after signing a final separation agreement or agreeing to a final court order, parties will agree to some kind of parenting coordination, a process by which they agree, in advance, to delegate to a specified family law professional the ability to mediate and, if necessary, adjudicate on matters relating to the interpretation of the agreement or order or gaps that arise as a result of unforeseen issues. Parenting coordination was recently defined in McClintock as follows: parties who enter into separation agreements often appoint a parenting coordinator, who will assist in resolving day-to-day issues that come up in parenting children. Parenting coordinators tend to be social workers or psychologists who have experience in family law issues. When appointed, they can only assist the parties through logic and persuasion to make accommodations. In some cases, it has been thought to give a parenting coordinator the right to make decisions where the parties cannot agree. In such a case, the person can make binding decisions in addition to using his or her powers of persuasion to assist the parties. Usually, but not always, the parties agree at the time they are concluding their matter on who the PC will be. If they do not, they often have to argue as to who the PC will be at the time the issue arises, a situation that is less than ideal. Family arbitrations conducted in accordance with a separation agreement, court order, or family arbitration award providing for the arbitration of possible future disputes relating to the ongoing management or implementation of the agreement, order, or award are secondary arbitrations. FLA, S 59.7. 2. Although independent legal advice is not required for purposes of secondary arbitrations. FLA, S 59.7. 1. 2. PCs almost always have the parties review and sign a parenting coordination agreement prior to commencing any work and will expect the clients to each obtain independent legal advice before it is signed. It is crucial to identify in the parenting coordination agreement what topics over which the coordinator will and will not have jurisdiction. Failure to do so could result in unintended consequences where one party expects the coordinator has the power to make decisions in an area the parties may not have contemplated at the time the separation agreement or court order was entered into. Decisions made by PCs are treated identical to those made by arbitrators, called awards. They are enforceable pursuant to the provisions of the FLAS 59.6. 1. Chapter 60 Domestic Contracts. 1. Introduction. There are 5 types of domestic contracts that are permitted in Ontario, as set out in Part IV of the Family Law Act. FLA, cohabitation agreements, marriage contracts, separation agreements, paternity agreements, and family arbitration agreements. 1.1 Cohabitation agreements. Cohabitation agreements are usually entered into by unmarried couples. They can be signed before they start cohabiting or while they are doing so. They can be stated to become marriage contracts if the parties subsequently marry. They can deal with all financial aspects of their relationship, including rights and obligations on its termination, but not custody or access. 1.2 Marriage contracts. These can be entered into prior to marriage or after marriage but before marriage breakdown. The same limits that apply to cohabitation agreements apply here. Pursuant to S52 of the FLA, the following issues can be dealt with in a marriage contract: ownership in or division of property, support obligations, the right to direct the education and moral training of children but not the right to custody or access to children, and any other matter in the settlement of the parties' affairs. However, a provision purporting to limit a spouse's right to possession of the matrimonial home is unenforceable, as are any other restrictions of a spouse's rights under Part 2 of the FLA. Of particular importance to marriage contracts is S59.4, which provides that a family arbitration agreement and an award made under it are unenforceable unless the family arbitration agreement is entered into after the dispute to be arbitrated has arisen. 1.3 Separation agreements. These are by far the most common domestic contract. Virtually every separated couple who does not litigate to the point of a judgment and has anything that requires settling as a result of the separation will likely end up with a separation agreement. They deal with all rights and obligations arising from the relationship and its breakdown, usually on a permanent basis. 1.4 Paternity agreements. A paternity agreement is usually required in situations where the biological parents of a child, who are not married, are ending their relationship with one another. If the parents cohabited and then separated, a separation agreement would be required instead. The purpose of a paternity agreement is to set out the decision-making authority of each parent regarding the child's needs. In making these decisions, the parents should consider the child's best interests. Decisions include custody and access and child support. Child support issues will often address monthly child support, child care costs, extracurricular activities, and post-secondary education. 1.5 Family arbitration agreements. Pursuant to S51 of the FLA, family arbitration is defined as an arbitration that deals with matters that could be dealt with in a marriage contract, separation agreement, cohabitation agreement, or paternity agreement. Before any arbitration proceeding may commence, both parties must give their consent to participate by signing an arbitration agreement. This agreement stipulates that the parties waive the right to litigate the matter in court and sets out the conditions surrounding the arbitration, including who will arbitrate, where and when the arbitration will occur, and what issues will be arbitrated. It is important to carefully draft the arbitration agreement since the arbitrator is only authorized to decide issues that are specifically included in the agreement. In other words, any decisions made on issues that are not included in the initial agreement are unenforceable. Any determinations made by the arbitrator are incorporated into an award, which binds both parties and is legally enforceable. The conditions for enforceability are set out in S59.6, 1, of the FLA. Clause 59.6, 1, b, of the FLA states that a family arbitration award is enforceable only if each of the parties to the family arbitration agreement receives independent legal advice. 2. Formal validity. The FLA contains the code for domestic contracts, starting with what is required as formal validity. They must be in writing, signed, and witnessed. Independent legal advice. ILA is not a formal requirement, but is highly advisable to prevent challenges to the contract on other grounds. Where a lawyer feels that the party is not signing voluntarily, the agreement is unconscionable, adequate disclosure has not been provided, or any other ground upon which the contract may be attacked exists, the lawyer should recommend that the client not sign the agreement. If the client ignores the lawyer's recommendation and still wishes to proceed, the lawyer should generally decline to act. Please note that if a lawyer is unsure of what to do, the lawyer should seek advice from a senior member of the bar either directly or through an organization such as the Law Society of Ontario or the Ontario Bar Association. Parties do not have to be resident in Ontario to have a domestic contract to which Ontario law will apply. It must simply state that is their wish. If it does not, a domestic contract made outside Ontario is, under S58 of the FLA, governed by the proper law of the contract itself, that is, usually, the other state in which it was made, for the determination of the proper manner and formalities of the contract, but it is enforceable in Ontario if it meets Ontario's requirements. As discussed in this Chapter 3, Challenging Domestic Contracts. Section 56 of the FLA sets out the most common grounds relied upon to set aside a domestic contract, in whole or in part. A party to such a contract failed to disclose a significant asset or debt in existence when the contract was formed. A party failed to understand the nature and consequences of the agreement. Any other ground upon which an ordinary contract may be attacked. Complete and honest disclosure will eliminate the first ground. It appears that this must include accurate values for assets and liabilities, as well as income. However, for cohabitation and marriage agreements, exact values are less important so long as they are still reasonable. Independent legal advice will usually eliminate the second. The last basis includes fraud, which is usually a form of non-disclosure, duress, or undue influence. In 2004, the Supreme Court of Canada confirmed in Hartshorn v. Hartshorn that the unconscionability of a contract or term thereof can only be the basis of a successful attack if the deal is unfavorable to the challenging party and this result was caused by the other preying upon the weakness of the challenger. Both elements are required, i.e., it takes more than being a bad deal to set aside a domestic contract, especially regarding property provisions, if there has been full disclosure and ILA. Hartshorn also stands for the principle that a certain degree of deference should be given to domestic contracts, since private parties should be able to reasonably rely on the arrangements that they have made for their financial well-being upon the dissolution of their marriage. The unconscionability of a contract is to be determined upon the breakdown of a marriage with regard to the financial needs, means, and other circumstances of the parties. In 2008, the Court of Appeal for Ontario opined in Levan v. Levan that even once grounds to set aside a domestic contract have been found under S56 of the FLA, the determination as to whether the contract should be set aside is a purely discretionary matter for the court. In this determination, fairness is an appropriate consideration. There is a positive duty on every spouse to make complete, fair, and frank disclosure of all financial affairs, even if there has not been a request for information. While a sworn financial statement may not be necessary, a statement of net worth with an indication of how that value was determined and including disclosure of all assets and income may suffice. In 2018, the Court of Appeal for Ontario in Turk v. Turk held that a finding of a party's failure to disclose a significant asset will not automatically result in a domestic contract being set aside. The court stated that non-disclosed assets are not to be considered in isolation, but rather, should be compared to the value of the party's total assets. In this case, the court concluded that the parties, in mediation, had negotiated a favorable settlement for the wife, which had been incorporated into a separation agreement. The trial judge had correctly assessed the significance of the non-disclosed assets in the context of the settlement and determined that the disclosure would have not greatly changed the outcome of the mediation. 4. Overriding support terms of a domestic contract. This mainly pertains to support provisions. Under Part 3 of the FLA, unconscionable support provisions, which would include a release of support rights, may be set aside or varied by the courts. S33. 4. Mere unfairness is insufficient. The unconscionable circumstances are assessed as of the date of the hearing. Under the Divorce Act, the test set out in Miglin v. Miglin is used. 5. Domestic contracts filed with the court. Section 35 of the FLA permits a party to file a domestic contract with the court along with an affidavit stating the domestic contract remains in effect and has not been set aside. Filing a domestic contract with the court allows for the support provisions contained in the document to be enforced by the Family Responsibility Office and varied or recalculated by the court. S35. 2. A domestic contract that has been filed with the courts can also be set aside by court order. 6. Independent legal advice. What should a lawyer do when a potential client presents the lawyer with a domestic contract that has already been drafted by the other side and is simply awaiting execution? The first question that a lawyer must consider is whether ILA is adequate or if a recommendation of legal representation is required. In situations where there is time for negotiations and where there are complex issues with multiple options to consider, it may be more appropriate to recommend that the potential client obtain legal representation. Where time is short, where the parties have already negotiated most of the agreement, where the issues are few in number and degree of complexity, or where the contract comes to the lawyer as a fait accompli, a client may choose ILA. If ILA is adequate or the client waives the right to legal representation, which waiver has been reduced to or confirmed in writing, the lawyer may provide the client with ILA. Assuming that ILA is appropriate and the lawyer is competent and does not have any conflicts in the matter, the lawyer providing ILA must explain the legal aspects of the domestic contract to the client. and satisfy himself or herself that the client understands the advice given. A client who retains a lawyer for the limited service of ILA is still a client. The lawyer should not merely go through the motions of providing legal advice. As with any other client, the lawyer should open a file, confirm the client's instructions in writing, retain a copy of any relevant client documents that were reviewed, make notes of any meetings and advice given, docket the time spent, send a reporting letter and statement of account, and include the client's name in the lawyer's conflicts checking system. The lawyer retained to give ILA with respect to a domestic contract should consider the following. The lawyer should get to know the client by exploring the current state of the client's relationship or marriage, the client's health, the net worths of both the client and the client's future, former, or current spouse, the presence of domestic violence, and the client's objectives for entering into the domestic contract. The lawyer should satisfy himself or herself that the client is signing the domestic contract freely and voluntarily, and not under duress, undue influence, or pressure from anyone. Any payments to the lawyer should come from the client only, and not from anyone adverse in interest. The lawyer should ensure that there has been complete financial disclosure. The contract accomplishes the client's objectives. The terms are certain and enforceable. All statutory and common law requirements have been met, and the contract's provisions are not unconscionable. The lawyer should explain the nature of the agreement and review its effect, risks, and consequences. The lawyer should satisfy himself or herself that the client understands the advice given. If the lawyer advises against signing the contract but the client wishes to proceed, it would be prudent for the lawyer to explain the lawyer's advice in the presence of a witness and require the client to sign an acknowledgement, in front of the witness, that the client is signing the documents against the lawyer's advice. Use of a checklist helps to ensure that all the issues are covered when discussing a domestic contract. It can also support the lawyer in successfully defending a negligence claim with respect to the ILA. A completed checklist should be placed directly in the client's file. A sample ILA checklist can be found on the LAWPRO website. Finally, an ILA certificate is usually appended to the end of the domestic contract, which is returned with the signed domestic contract to the other party's lawyer as proof that the client has received ILA. The ILA certificate normally certifies that the lawyer acted for the client and has explained the nature and effect of the domestic contract, acknowledges that the client understood the nature and effect of the agreement and that the client executed the agreement in front of the lawyer, and confirms that the client was entering the contract on the client's own volition, without any fear, threats, compulsion, or influence by any other person. As long as the lawyer can confirm the substance of the ILA certificate, the lawyer may sign it. In some circumstances, a lawyer may refuse to sign the ILA certificate where the client insists on signing the domestic contract against the lawyer's advice. Chapter 61 Representing a Victim of Domestic Abuse 1. Introduction. From the moment a client advises that the client has been a victim of domestic violence, the issue of violence impacts upon every decision in a family law file. This chapter discusses the issues that arise when a client has been a victim of domestic violence. 2. Initial disclosure of abuse. The first thing a lawyer must do when advised by a client that the client has been a victim of domestic violence is attempt to assess existing and potential risks to the client and any children in the household. The significance of the alleged abuse will vary greatly depending on the frequency, type, and severity of the abuse. The lawyer should attempt to determine whether the abuse is escalating. Victims of abuse often understate the extent of the abuse. They may do this because of embarrassment or fear, or as a coping mechanism. In some cases, abuse victims have simply lost the ability to recognize abuse. If someone has lived with abuse for an extended period of time, abusive behavior may have come to seem like normal behavior. To understand the extent of the violence, the lawyer must ask very specific questions to elicit information in order to gain an accurate understanding of the situation. Building trust with the client is an important part of working with victims of domestic violence or abuse. There are numerous issues to consider in cases of abuse. First is whether there is immediate physical risk to the client. If the parties are still residing together, is it safe for the client to return to the home? Does the client have a support system and an emergency system in place? If they are not residing together, is a restraining order necessary to ensure the client's safety? Should a report be made to the police? If there are children, it must be determined if they are at risk. Have they also been victims of abuse? Have they witnessed abuse? In some cases, an abusive spouse uses threats about the children as a method of control, telling the victim that if the victim does something the abuser does not like, such as seeing a lawyer or leaving the marriage. The abuser will hurt or kidnap the children. Have such threats been made? Does the abusive partner have the means and opportunity to act upon them? Are the children's documents, e.g., birth certificates and passports, accessible? The lawyer must not only consider the immediate risk but also recognize that the level of risk may change as various steps are taken. For example, how will the abusive spouse react when served with pleadings? If the abuser is likely to become violent when served with pleadings, how can the lawyer ensure the client's safety? Most lawyers have not received clinical training in respect of domestic violence and are not therapists. It is prudent for family lawyers to familiarize themselves with appropriate services within their community. For example, private therapists, clinics, and shelters, to whom they can refer clients to obtain necessary supports. This is a critical service for the client and an important way to avoid blurring professional boundaries and roles. In addition, clinical professionals may be able to offer assistance and guidance to both the client and the lawyer in developing appropriate ways to address the situation. Independent evidence of the abuse will be extremely helpful if the parties end up in litigation. The lawyer should attempt to determine if such evidence is available. Are there people who witnessed the violence? If not, did the client ever report the violence to a doctor or a friend? Did the client ever call the police? If not, why not? If the victim has been struck recently, bruises or other marks may be visible. If so, photos should be taken. Once the lawyer has an understanding of the nature of the abuse, the client's options can be discussed. In some cases, clients will choose to leave the home immediately and go to a shelter or stay with family or friends. If the client chooses to return home for even a short period, the lawyer should develop a safety plan with the client in case the client has to leave the home quickly. The client needs to think about where to go if required to leave quickly. The lawyer should also consider other non-family law issues related to the domestic violence and separation. For example, is the client eligible to receive supports and services through the Victim Quick Response Program Plus? The lawyer should also consider the client's immigration status and whether the separation will impact that status. Referrals to lawyers with expertise in other areas, e.g., immigration, may be necessary. 3. Mediation or litigation? Lawyers will need to advise their clients on how to enforce their family law rights. In most family law proceedings, lawyers recommend that clients attempt negotiations and/or mediation before commencing litigation. This is rarely appropriate in cases involving domestic abuse for both practical and psychological reasons. On a practical level, it is unlikely that a victim of abuse can safely stay in the home while negotiation or mediation is attempted. Negotiating a separation is difficult and generates strong emotions including pain, anger, and betrayal. In many abusive situations, a client will not be safe once the abusive spouse realizes that the client intends to leave the relationship. If the victimized spouse has to leave the home, there may be no time for negotiations or mediation. It may be necessary to obtain emergency relief from a court, possibly without notice, including a restraining order, an interim custody order, and interim support. Even if the abuse victim is physically safe and financially self-sufficient, mediation may not be appropriate. If mediation is considered, it is important that the mediator screen for domestic violence and power imbalances prior to commencing the mediation. The fundamental problem with mediation in situations of abuse is that there is often a power imbalance between the abusers and victims, and the dynamics of abusive relationships do not lend themselves to fair or respectful negotiations. To protect themselves, many victims of abuse become appeasers in their relationships. They avoid expressing views that may provoke anger. If they do express a view that provokes an angry response, they will often immediately abandon it to avoid conflict with the abuser. Abusers often learn how to control the victim without direct abuse or threats. They may be able to intimidate the victim using subtle gestures, speech, or even glances. These dynamics are hard to change and make it unlikely that abuse victims could assert their interests in mediation. 4. Proposed Divorce Act changes. On June 21, 2019, Bill C-78 received royal assent. This bill makes significant changes to the Divorce Act and is expected to come into force on July 1, 2020. The current Divorce Act does not specifically address the issue of family violence, and Bill C-78 seeks to rectify this omission. Once Bill C-78 comes into force, courts will be required to consider the impact of family violence when considering various claims for corollary relief for married spouses. Family violence under Bill C-78 78 will be broadly defined as conduct that is violent or threatening or that constitutes a pattern of coercive and controlling behavior or that causes a family member to fear for that family member's own safety or for the safety of another person. The behavior will include, but is not limited to, physical abuse, sexual abuse, threats of harm, harassment, psychological abuse, and financial abuse. In the case of a child, family violence includes the direct or indirect exposure to such conduct. In situations of domestic violence, there is often a crossover with other areas of law, and individuals may also be involved with the criminal justice system or child protection services. Victims of domestic violence may have also obtained a civil restraining order to protect themselves or their children. In a proceeding for corollary relief, under Bill C-78, courts will be required to consider whether any of the following are pending or in effect, unless it is not appropriate to do so: a civil protection order or proceeding, a child protection order, proceeding, agreement, or measure, or an order, proceeding, undertaking, or recognizance in relation to any matter of a criminal nature. In determining the best interests of a child, courts will be required to consider any family violence and its impact on, among other things, the ability and willingness of any person who engaged in family violence to care for and meet the needs of the child and the appropriateness of making an order that would require individuals to cooperate on issues affecting the child. Further, in considering the impact of family violence on the best interests of a child, courts will need to take into account factors that include, but are not limited to, the nature and severity of the violence, whether there is a pattern of coercive control, whether the violence was directed towards the child, whether the child was exposed to the violence, the harm or risk of harm to the child, and steps taken by the person engaging in the family violence to prevent future violence from occurring and improve the person's ability to care for and meet the needs of the child. The risk of family violence will also be taken into account when determining whether a parent is required to provide notice of their intent to change the child's residence. 5. Conduct of litigation. 5.1 Drafting the application. Often in cases involving domestic violence, a lawyer will be under pressure to commence litigation immediately and bring a motion for urgent relief. The focus can easily be on the motion material with little attention paid to the application. The lawyer should take the time required to draft the application effectively. The relief sought in situations of domestic violence may differ from other family law proceedings, so the application must clearly identify the fact that there has been domestic violence. The following issues should be discussed with the client. 5. 1. Exclusive possession. The client may want an order for exclusive possession of the matrimonial home. If so, this must be sought in the application. This relief is only available if the parties are married. Section 19 of the Family Law Act FLA states that both spouses have an equal right to possession of the matrimonial home. Section 24 overrides that section, stating in S24, 1b, that the court may give one spouse exclusive possession of the home. Subsection 24, 3, sets out the criteria a court must consider in determining whether to make an order for exclusive possession. One of the criteria is any violence committed by a spouse against the other spouse or the children. The court is also directed to consider the best interest of any children affected and the availability of other affordable accommodation. A single incident of abuse, unless it entails significant physical violence or threat of physical violence, may not be sufficient to obtain an order for exclusive possession. If there is a history of abuse, the application should make this clear without going into excessive detail. The specific descriptions will be provided in affidavit material. If there is evidence of a history of abusive behavior, a court is unlikely to permit the abuser to remain in the home and require the rest of the family to obtain alternate accommodation. While the remedy of exclusive possession under S24 of the FLA is limited to married spouses, there is conflicting case law regarding whether a common law spouse can apply for exclusive possession of the home as an incident of support. 5. 1. To restraining order. In many cases of domestic violence, some form of restraining order will be needed. Even if the victim is granted an order for exclusive possession, that will not protect the victim or the children while they are away from the home. The client may want an order preventing the abuser from attending at the client's place of employment. If there has been violence towards the children or threats of abduction, the lawyer should seek an order restraining the abuser from having contact with the children, as well as an order precluding the abuser from removing the children from the province of Ontario without a court order. An order that specifically restrains the abuser from attending at the children's school may be helpful in ensuring that the school staff does not allow the abuser to pick up the children from school. Significant amendments to Ontario legislation regarding civil restraining orders were made in October 2009. Under S35(1) of the Children's Law Reform Act (CLRA), a court may make a temporary or final restraining order against any person if the applicant has reasonable grounds to fear for the applicant's safety or for the safety of a child in the applicant's lawful custody. Subsection 46(1) of the FLA permits the court to make a temporary or final restraining order against the applicant's spouse or former spouse or against a person with whom the applicant is cohabiting or has cohabited for any length of time. Restraining orders under the CLRA or the FLA must be made in the appropriate form prescribed by the family law rules. Rules R25, 11.1, and Forms 25F25G. The order may contain provisions restraining the respondent from communicating directly or indirectly with the applicant or any child in the applicant's lawful custody, restraining the respondent from coming within a specified distance of one or more locations, and any other term the court considers appropriate. Where the court is of the view that a restraining order is not required or appropriate, there are other mechanisms under which orders may be made to constrain the respondent's behavior. For example, S28(1)(c) of the CLRA enables the court to make a variety of orders such as limiting the duration, frequency, manner, or location of contact or communication between the parties or between a party and the child. In addition, when making an order dealing with family property, the matrimonial home, or support under the FLA, the court may now make a temporary or permanent order prohibiting a party from directly or indirectly contacting or communicating with another party. FLA, SS 13.1, 25.1, and 47.1, 5.1, 3 Custody, access, or parenting time. Current federal and provincial legislation including the Divorce Act, FLA and CLRA, use the language of custody and access to describe a parent's rights and obligations with respect to a child. However, once Bill C-78 comes into force, the terms custody and access will be removed from the Divorce Act. Rather, the federal legislation will speak of parenting orders, which will set out parenting time and decision-making responsibility. If the client wants the sole ability to make decisions for their child, the client should be encouraged to seek sole custody or sole decision-making. Joint custody or joint decision-making is usually not workable in abuse situations since it requires a level of cooperation and respect that is not present. The issue of access or parenting time is also affected by domestic violence. If abuse has been directed at the children, the client may want to seek an order for supervised access or supervised parenting time. In an extreme case, an order preventing any access or parenting time may be appropriate. If there are ongoing visits, how should pick-up and drop-off be arranged to minimize the risk of contact between the victim and the abuser? Even if the children were never direct victims of abuse, other issues arise. Are the children likely to suffer abuse in the future? If the children have witnessed abuse in the home, they may require some form of therapeutic intervention. A growing body of research suggests that children who are exposed to violence between their caregivers are at an increased risk of psychological, social, emotional, and behavioral disorders. Subsection 24(4) of the CLRA specifically directs the court, in assessing a person's ability to act as a parent, to consider whether the person has at any time committed violence or abuse against the person's spouse, a parent of the child to whom an application relates, any member of the person's household, or any child. Bill C-78 ensures that the impact of family violence will be considered in the Divorce Act as well. Parenting issues can be bitterly contested and very difficult to resolve. Because of this, when drafting an application in an abuse situation, the lawyer should discuss with the client whether to seek an order for a custody and access assessment pursuant to S-30 of the CLRA or to request an investigation and report by the children's lawyer pursuant to S-112 of the Courts of Justice Act. If these forms of relief are likely to be required, they should be sought in the application. 5.1. For spousal support. The existence of domestic violence can have an impact on the issue of spousal support. Subsection 15.2(5) of the Divorce Act prohibits a court from taking into consideration spousal misconduct in determining the issue of spousal support. However, if the abuse has left the victim emotionally and/or physically traumatized to such a degree that the victim's ability to work is temporarily or permanently compromised, that should be set out in the application as a factor to be legitimately considered as relevant to the issue of support, including the quantum of support. In particularly serious situations, consideration should be given to seeking damages. In the context of either of these forms of claim, the lawyer must consider the necessity of providing evidence of impairment or injury resulting from the abuse. 5.2 Emergency motions. As discussed above, victims of abuse often need some emergency relief from a court. A restraining order may be necessary to ensure the client's safety. If there is a concern that the abuser may try to abduct the children, a non-removal order may be necessary to ensure the children are not removed from the province of Ontario without a court order. If the client has left with the children, the client will need an interim custody or interim parenting order. If the client is financially dependent on the abusive spouse, support will be required. If the client wants to return to the matrimonial home, an order for exclusive possession is required. Rule 14 of the rules prohibits a motion prior to a case conference. In many jurisdictions, it can take weeks or months to get a date for a case conference. In most family law proceedings, it will be several weeks or months before any court orders are made. Such a delay can be dangerous in abuse situations. At a minimum, it will create very serious hardship for most abuse victims. The courts recognize this and will grant leave to hear emergency motions in cases of urgency or hardship, which may include situations involving abuse. Rules. R14. 4.2. 6. Drafting orders in situations of domestic violence. It is critical to draft court orders carefully. The orders often have to be understood and enforced by third parties such as the police. Any ambiguity may lead to confusion and failure to enforce the order. As noted above, restraining orders made under the FLA or the CLRA must be in the prescribed forms under the rules. The terms of the order should be detailed and specific. For example, if there is an order that the abuser not attend at or near the children's school, the name and address of the school should be specified. The use of a geographic restriction, e.g., not to be within 200 meters of a specific location, is recommended as an aid to enforcement. The terms of the access or parenting order should be drafted as clearly as possible. For instance, if the abuser is entitled to see the child on alternating weekends, the order should specify the date of the first weekend so that the order can be used to determine if a later weekend is an access weekend. If the abuser is not entitled to see the child, that should be set out rather than simply leaving the order silent as to access or parenting time. Finally, it is important that the order specifically state that it is to be enforced by any peace officer whose assistance is requested for the purpose of enforcing the order. The order should specifically mention the police force in the jurisdiction in which the client resides and should include mandatory language requiring the police to locate and apprehend a child, if necessary. Many police officers will not enforce the terms of an order unless the order specifically directs the police to do so. Reference should be made to the relevant statutory provision relied upon to obtain the restraining order, and the words of the statute should be mirrored in the order. Chapter 62 Child Protection Law in Ontario. The substantive law governing child protection proceedings in Ontario is found in Part 5 of the Child, Youth and Family Services Act, 2017. CYFSA. The CYFSA came into force on April 30, 2018, and the previous child protection legislation, the Child and Family Services Act, CFSA, was repealed. Part 10, Personal Information, of the CYFSA came into force on January 1, 2020. The procedural law governing child protection proceedings in Ontario is in the Family Law Rules, in general and R33 in particular. This chapter highlights the most significant provisions of the CYFSA and gives an overview of the steps in a child protection proceeding. 1. Background. A child protection application is a civil proceeding, therefore the burden of proof to be met is on a balance of probabilities, not the higher standard of proof beyond a reasonable doubt that is required in criminal law. Unlike other civil proceedings, however, in most child protection applications, the state, as represented by a Children's Aid Society (CAS), is the moving party. The potential consequences for an individual's liberty and security in a child protection proceeding are often at least as dire as those faced in criminal law proceedings. If a child is found to be in need of protection, the court may make an order that has the effect of separating parents and children from each other, temporarily or permanently. In New Brunswick, Minister of Health and Community Services, VG, J, and Winnipeg Child and Family Services VKLW, the Supreme Court of Canada held that S7 of the Canadian Charter of Rights and Freedoms, Charter, is engaged in child protection proceedings, as in criminal proceedings. In child protection proceedings, private individuals are faced with litigating against a state agency that has significantly greater resources. Courts often tend to view the CAS as a more impartial party and, therefore, more deserving of credibility where there is a factual dispute. This is by no means a level playing field, and it is important for counsel to, while maintaining civility, ensure that the CAS is required throughout the proceeding to adhere to its statutory and regulatory obligations if the parents are to have any reasonable prospect of success. In addition, it is important to ensure that the CAS respects the procedural rights afforded to parents given the serious consequences that may result from its intervention. CASs are created under the authority of the CYFSA and designated by the Minister of Children, Community and Social Services. They function within defined geographical and, in some cases, ethno-religious jurisdictions. Their duties are outlined in S35, 1, and include investigating allegations that children may be in need of protection and taking steps to protect them. The CYFSA allows a CAS to intervene if there are reasonable grounds to believe that a child is at risk of harm. If a CAS receives information that a child is at risk of harm, it must investigate the allegation and determine whether to verify it. When an allegation is verified, the CAS must decide what, if any, intervention is required to protect the child. Province-wide protocols have been developed in regard to the investigation, verification, and assessment of risk. There is a positive obligation imposed upon all persons in Ontario to report any reasonable suspicion that a child is in need of protection to the local CASS 125. In the case of certain professionals and persons working with children including lawyers, a failure to report can lead to prosecution. With the exception of lawyer-client privilege, this duty overrides any professional or statutory privilege. The duty to report does not apply with respect to a child who is 16 or 17 years old. S 125. 4. Previously, protection under Part 3 of the CFSA was limited to children under the age of 16 years at the time of intervention. Now, CASs have authority to investigate allegations and protect children under 18 years of age. CASs also have the ability to enter into a written agreement for voluntary services for a child who is 16 or 17 years of age. S77. The CYFSA indicates that CASs are permitted to bring a child to a place of safety, formerly known as an apprehension, if the child is under 16 years of age. SS 81. 2. and 7. However, a CAS can bring a 16 or 17-year-old child to a place of safety if the child is subject to a temporary or final supervision order and the child consents. S82. 1. 1.1 Preamble. The CYFSA begins with the preamble, which sets out various acknowledgements and commitments of the Government of Ontario regarding the provision of services under the CYFSA. Through the preamble, the government acknowledges that children are individuals with rights to be respected and voices to be heard. The government also indicates it is committed to the following principles. Services provided to children and families should be child-centered. Children and families have better outcomes when services build on their strengths. Services provided to children and families should respect their diversity and the principle of inclusion. Systemic racism and the barriers it creates for children and families receiving services must continue to be addressed. Services to children and families should, wherever possible, help maintain connections to their communities. In furtherance of these principles, the government acknowledges that the CYFSA is to be consistent with and build upon principles in the United Nations Convention on the Rights of the Child. The preamble also sets out the government's acknowledgements and beliefs with respect to the First Nations, Inuit, and Métis children. With respect to these children, the government is committed, in the spirit of reconciliation, to working with First Nations, Inuit, and Métis peoples to help ensure, wherever possible, they care for their children in accordance with their distinct cultures, heritages, and traditions. 1.2 Children and young persons' rights. While the CFSA specified the rights of children and young persons in various parts and sections, the CYFSA consolidates these rights into Part 2 and provides for additional legislated rights. Clear statements regarding the rights of children and young persons are an important feature of the CYFSA. This is demonstrated in the preamble and at the outset of Part 2, which contains a new statement that enumerates the rights of children and young persons with respect to matters that affect them and the services provided to them. 1.3 First Nations, Inuit, and Medis. The CYFSA repeals the old language of Indian and native person that was contained in the CFSA. Children and persons may now self-identify as First Nations, Inuit, and Métis and may identify with more than one band or community. This approach is inclusive of status and non-status First Nations, Inuit, and Métis persons too. Protection applications 2.1 Commencing an application if it is possible to do so while adequately ensuring the safety of the child. The CAS is expected to attempt to work with the family on a voluntary basis to address any concerns without the need for court intervention. The CYFSA clearly emphasizes at S1, 2, the importance of taking the least disruptive course of action where possible and exploring the provision of prevention services, early intervention services, and community support services. However, if voluntary measures are deemed to be insufficient, whether due to the severity of risk or actual harm or because the parents are viewed as uncooperative, the CAS may commence a protection application. In cases of imminent risk of harm, the CAS may bring a child to a place of safety. A place of safety is defined in S74, 1, and 4 of the CYFSA. This definition includes, but is not limited to, a foster home, a hospital, and a family or community member's home. The CAS may bring a child to a place of safety with or without a warrant and can obtain the assistance of the local police force to effect the child's removal to a place of safety. If the CAS brings a child to a place of safety, the matter must be brought before a court within 5 days. R33. There is no requirement that the CAS facilitate any contact between the child and the parents during this period of time. 2.2 Finding a child in need of protection. The term a child in need of protection is defined in SS 74, 2, of the CYFSA and does not involve an analysis of whether the family of origin offers the best possible environment for the child. The list at S74, 2, is extensive, ranging from actual or potential physical, sexual, emotional, or developmental harm to parents who are unable to exercise custodial rights or care for the child, and includes both harm by commission and harm by omission. It is necessary to have close regard to the definitions, particularly in reference to the emotional harm categories, to determine whether the CAS can adduce the necessary evidence to bring the case within one of the definitions. This determination of whether a child is in need of protection is referred to as the finding, and it should be determined within 3 months of the commencement of the application. S96. If the CAS cannot satisfy a court that the subject child and family meet the criteria for a finding under one of the available categories, no order can be granted under the CYFSA, and the application will be dismissed. 2.3 Orders that can be sought. The type of order a CAS will seek in a protection application, provided that the child is found to be in need of protection, will depend upon the perceived nature and degree of risk to the child. This is what is referred to as the disposition stage of the proceeding, and the applicable test is the best interests of the child as defined in S74, 3. The enumerated criteria to be considered in determining the best interests for the purposes of the CYFSA are not identical to those set out in the Children's Law Reform Act (CLRA), which governs private custody access disputes. In determining the best interests of the child, consideration must be given to the child's views and wishes and, in the case of a First Nations, Inuk, and Métis child, to the importance of preserving the child's cultural identity and connection to community. In addition, the person making the determination in the best interests of the child can consider any other circumstances of the case that the person considers relevant, including the child's needs, risk of harm, child's identity, child's relationships to members of the child's family or community, continuity of care, and permanency planning. The available disposition orders vary in severity from leaving the child in the parent's care with or without CAS supervision at one extreme, to an order placing the child in extended society care without access by the parents at the other. Section 101 of the CYFSA outlines the orders a court may make. These include a supervision order with or without terms and conditions, an order placing the child in interim society care, formerly known as a society wardship order, and an order placing the child in extended society care, formerly known as a Crown wardship order, through which parental rights and responsibilities are transferred indefinitely to the state. Section 101 contains specific directions about what is considered in determining which disposition is in the child's best interest. These directions reflect the legislative intention to attempt to keep a child within the child's family or community if that is possible. To that end, the CYFSA provides the following. Subsection 101. 2. Directs the court to ask the parties what efforts the CAS has made to assist the child before commencing a protection application. Subsection 101. 3. Directs that no order shall be made for the removal of a child from the child's home unless the court is satisfied that alternatives that are less disruptive to the child, including non-residential services and the assistance available through community resources, would be inadequate to protect the child. Subsection 101. 4. Directs that if the court has decided that it is necessary to remove the child from the child's home, before making an order placing the child in interim or extended society care, the court must consider whether it would be possible to place the child with a relative, neighbor, or other member of the child's community or extended family. Subsection 101. 5. Directs that if the child is First Nations, Inuk, or Métis, the court is required to place the child with a member of the child's extended family or with another First Nations, in the case of a First Nations child, Inuit in the case of an Inuk child, or Métis, in the case of a Métis child family, unless there is a substantial reason for placing the child elsewhere. There is also the possible disposition of granting custody to a person or persons other than a foster parent. S102. Although the initial S102 custody order is made pursuant to the CYFSA without the need of a separate proceeding, future applications to vary the order are brought under the CLRA, notwithstanding that a S102 custody order may be varied through a CLRA proceeding. Such an order retains the style of cause of the original protection proceeding. For this reason, custodial caregivers sometimes prefer to proceed with a standalone custody application under the CLRA, which if successful, would enable the CAS to withdraw or terminate its application for rights of the child if the child who is the subject of a protection application is 12 years of age or older. The child has the right to receive notice of the proceeding and to be present at the hearing, unless the court is satisfied that being present at the hearing would cause the child emotional harm. S79. 4. Even if a child is not 12 years of age, the court may direct that legal counsel be provided to the child if the court determines that legal representation is desirable to protect the child's interests. S78. If legal representation is provided to a child, the child is entitled to participate in the proceeding and to appeal as if the child were a party. S79. 6. Finally, a parent who is less than 18 years of age shall be represented by the office of the children's lawyer unless the court orders otherwise. S78. 5. 2.5 Timetable for the application. It is critical for both the child and the parents that the protection application be dealt with as quickly as possible. It is clearly undesirable for children to suffer prolonged uncertainty about where and with whom they will live. Parents are prejudiced by protracted proceedings in that the longer their child is out of their care and becomes physically and emotionally dependent upon others, the greater the chance the child will become psychologically attached to the new caregivers and experience diminished attachment to the parents. There is a very real risk that the passage of time alone can defeat the prospect of reintegration even if the original concerns that led to the child to be brought to a place of safety cannot ultimately be proven by the CAS. There seems to be an ill-defined point at which the risk of disruption to the attachment between the child and long-term caregivers, albeit caregivers paid by the state, takes priority over the family of origin and cultural connections. Both the CYFSA and the rules have provisions that attempt to ensure that a protection application moves quickly through the system. Rule 33 of the rules establishes the following timetable for all child protection cases. First hearing if a child has been brought to a place of safety no more than 5 days from the start of the case. Service of answers and plans of care no more than 30 days from the start of the case. Temporary care and custody hearing no more than 35 days from the start of the case. Settlement conference no more than 80 days from the start of the case. Hearing trial no more than 120 days from the start of the case. The parties may not lengthen the time shown without leave of the court, and the court may grant leave only if it is in the best interests of the child. Subsection 94. 1. Of the CYFSA provides that a court may not adjourn a hearing for more than 30 days unless all parties present and the person who will be caring for the child during the adjournment consent. Unfortunately, given the realities of the family court system, these timelines are more often honored in their breach. An important restriction on the length of time a protection application may continue is set out in S122 of the CYFSA. Section 122 prohibits a court from making an order that results in a child who is under 6 years of age at the time of the order being in care for a period of more than 12 months. consecutive or cumulative in the preceding 5 years. A child 6 years or more at the time of the order may not be in CAS care for more than 24 months. By preventing a child from being in interim society care indefinitely, S-122 attempts to ensure that the court makes a decision about the child's permanent placement within a reasonable time frame. The court may extend the 12 and 24-month periods by 6 months if satisfied that to do so is in the child's best interest. S-122. 5. 2.6 Evidence. Despite certain analogies between criminal proceedings and child protection proceedings, as noted above, child protection applications differ significantly from other judicial proceedings in that there are certain exceptions to the ordinary rules of evidence. One such exception is found at S93, 1, of the CYFSA. That subsection provides the following. 93, 1. Despite anything in the Evidence Act, the court may consider the past conduct of a person toward any child if that person is caring for or has access to or may care for or have access to a child who is the subject of the proceeding. And b. Any oral or written statement or report that the court considers relevant to the proceeding is admissible into evidence. In addition, S94, 10, of the CYFSA allows the court to admit and rely on evidence that it considers credible and trustworthy in the circumstances for the purpose of determining a child's placement during adjournments. The rationale for this less rigorous evidentiary approach appears to be that a child's safety should not be jeopardized by unduly restrictive rules of evidence. 2.7 First appearances indicated in R33. If a child is brought to a place of safety, there must be a hearing within 5 days. Section 88 of the CYFSA also directs the court to hold a hearing within 5 days after a child is brought to a place of safety. In practice, this is unrealistic since the parties will seldom have assembled the evidence necessary to argue the issues. An order made at the first appearance is usually without prejudice to the rights of all parties to argue all issues at the temporary care and custody hearing. The court may adjourn the hearing for 30 days pursuant to S94 of the CYFSA. But it will be asked to determine what temporary order is necessary, if any, to protect the child from harm while the parties prepare their evidence for the temporary care and custody hearing. The orders a court may make at this stage are outlined in S94, 2, of the CYFSA. If the court decides that a child must remain in the care of the CAS pending the temporary care and custody hearing, it can make an access order with such terms and conditions as it considers appropriate. S94, 8. 2.8 Temporary care and custody hearing. At the temporary care and custody hearing, the court will determine who shall have care and custody of the child pending final disposition of the application. If the CAS seeks to keep the child in its care, it must meet the test set out in S94, 4, of the CYFSA. First, the CAS must prove that there are reasonable grounds to believe there is a risk that the child is likely to suffer harm if returned home. The CAS must also prove that the child cannot be adequately protected by being returned to or remaining in the care of the person or persons who had charge of the child prior to intervention with CAS supervision, or by being placed in the care and custody of a relative of the child or a member of the child's extended family or community with CAS supervision. This section makes it clear that the emphasis of the legislation is to keep a child within the child's family or community if that is possible. Because the CAS has an obligation to work with the child's family, it is generally not in the parent's interest to treat the CAS as if it were simply an adversary in litigation. Parents and their counsel should stay in communication with the CAS and determine what its specific concerns are and how they are expected to be addressed. If the concerns arise from inaccurate information, the parents can work with the CAS to help it obtain a more accurate understanding of the family. If the CAS has legitimate grounds for concern, the parents can report to the CAS about progress they have made in addressing those concerns. The best way for parents to resolve a protection application is to work with the CAS in developing a plan of care for the child that will address the CAS's concerns and facilitate the reintegration of the family. 2.9 Access. The importance of maintaining meaningful contact between a parent and a child in care cannot be overemphasized in the child protection context. A wise judge once observed that protection cases are won or lost by the minute. If circumstances make it unlikely that a child will be returned swiftly to parental care, the focus of advocacy must be turned upon achieving maximum contact between the parent and child while an appropriate plan can be developed. Subsection 94, 8, provides that a temporary care and custody order may contain provisions regarding any person's right of access to the child on such terms and conditions as the court considers appropriate. The CAS will routinely, particularly at the commencement of proceedings, ask for an order that access be at its discretion. This is highly problematic. Absent at least a minimum requirement, e.g., 3 times weekly for 2 hours, the contact between the parent and the child will be governed largely by the CAS priorities, e.g., availability of volunteer drivers and foster parents' convenience. If the parent and child are not afforded the opportunity to have meaningful contact, then their relationship with one another will wither, and the relationship between the alternative caregiver and the child will likely gain importance. The younger the child, the greater the significance of the access arrangements. Infants attach through physical contact, familiarity, and routine. Section 104 of the CYFSA addresses access in Part 5 more generally and states that the court may, in the child's best interests, when making an order under Part 5, make, vary, or terminate an order regarding the person's access to the child or the child's access to a person and may impose such terms and conditions on the order as the court considers appropriate. This is an area where parents' counsel bears huge responsibility. The client must be made to understand that visitation with the child takes priority over every other demand. A parent who fails to visit the child at every available opportunity will be viewed negatively by the court and the CAS. Every effort should be made to provide appropriate child-focused alternatives to supervised access at the CAS offices. Friends, family members, and community agencies need to be canvassed as to their availability to host and, if necessary, supervise visits. The proposal must be tailored to address the specific safety concerns identified by the CAS, e.g., if the family home is unsafe or unhygienic, offer a different location. 2.10 Alternative dispute resolution if a child is or may be in need of protection. S17. 1 of the CYFSA requires the CAS to consider the use of alternative dispute resolution ADR, where it may assist in resolving any issue related to the child or the child's care, where the child is First Nations, Inuk, or Métis. S17. 2 of the CYFSA requires that the CAS consult with a representative chosen by each of the child's bands and First Nations, Inuit, or Métis communities to determine whether an ADR process established by the bands and communities or other prescribed ADR process could assist in resolving the issue. The CYFSA further provides that the court under S95 has the authority to adjourn a hearing under Part 5 of the CYFSA to permit the parties to use ADR if it is in the best interests of the child and the parties' consent. A skilled mediator is critical when engaging in ADR in the child protection context. Counsel should only agree to mediators with specific training and knowledge of child protection law and should choose mediators who are sensitive to the power differential between the CAS and the parents. 2.11 Assessments. The court may at any time, during the proceeding, order that a child, a parent, or any person other than a foster parent undergo an assessment within a specified period of time by a person appointed by the court. These assessments are frequently referred to as parenting capacity assessments. Section 98 of the CYFSA is the operative provision, and a special S98 endorsement sheet provides the format in which the order should be drafted. These assessments can be critical to the outcome of the proceeding, while the court is not bound by the assessors. Recommendations. The report is generally accorded considerable weight at trial, barring obvious flaws. An assessment report prepared pursuant to S98 of the CYFSA is evidence and is part of the court record of the proceeding. CS 98. 12. If a person refuses to undergo an assessment when ordered to do so under S98, the court may draw any inference it considers reasonable. S98. 13. No appeal lies from an order made under S98. S121. 2. 2.12 Final hearing. After the temporary care and custody hearing, a protection application proceeds pursuant to the rules. This requires a settlement conference and a trial management conference before the final hearing of the application, either through summary judgment or trial. The final hearing may involve a determination of a finding and disposition if a finding had not been made previously. Subsection 93. 2 of the CYFSA provides that evidence relating only to the disposition of the matter shall not be considered in determining if the child is in need of protection. 2.12.1 Summary judgment. In 2015, R16 of the rules was amended to adopt the changes made to R20 of the Rules of Civil Procedure and the statement of the Supreme Court of Canada in Hriniak v. Malden. Specifically, while R16 keeps the same legal test, whether there is no genuine issue requiring a trial, it also allows family court judges to weigh evidence, evaluate credibility, and draw reasonable inferences from the affidavit evidence before them when deciding whether to grant a motion for summary judgment. In addition, judges hearing summary judgment motions are able to order oral evidence to be presented to determine whether there is a genuine issue requiring a trial. Although summary judgment motions are possible in child protection proceedings, the Court of Appeal for Ontario has stated that in assessing whether this is a fair process, courts must recognize the distinctive features of a child protection proceeding, which includes the charter implications and the reality of child protection litigants, who may be experiencing poverty and other forms of marginalization. Therefore, in determining whether there is a genuine issue requiring a trial, the court must exercise caution and apply the objectives of the CYFSA, including the best interests of the child. Ca Arthur Halliburton Children's Aid Society VMW, 2. 2 Trial. If a trial is ordered, the court maintains the right under R1, 7.2, to make procedural orders in furtherance of the primary objectives stated in the rules. Such procedural orders may include directions designed to shorten trials or limit the amount or length of evidence presented. Counsel for parents should be very careful when procedural rights are restricted, particularly given the interests at stake. Any concern about such directions should be raised at the trial management conference or at the beginning of trial. Subrule 1, 7.4, states that an order under R1, 7.2, respecting how a trial is to proceed applies unless the trial judge orders otherwise. 2.13 Extended society care. An order for extended society care permanently transfers parental rights to the state. These orders are often referred to as the death sentence in child protection proceedings. The CAS, as the state's agent, assumes all custodial rights and responsibilities. Section 112 of the CYFSA requires the CAS to make all reasonable efforts to assist the child to develop a positive, secure, and enduring relationship within a family through adoption, a custody order, or a plan for customary care. In the case of a First Nations, Inuk, or Métis child, adoption extinguishes the parent-child relationship permanently, subject to post-adoption openness in certain cases. In the CYFSA, access will not be granted to a child in extended society care unless the access is in the best interests of the child and the relationship between the person and child is beneficial and meaningful to the child, and, if the court considers it relevant, the ordered access will not impair the child's future opportunities for adoption. S105, 6. In granting an access order, the court must specify every person who has been granted a right of access and every person with respect to whom access has been granted. S105, 7. Historically, access orders in favor of parents whose children were made permanent wards of the state were of crucial importance because a child could not be placed for adoption while an access order existed. Amendments in 2011 to the legislation have enabled a CAS to move forward with adoption planning notwithstanding the existence of an access order in favor of a parent, caregiver, or other person. CYFSA, S185, 2.14 Adoption and openness. When the CAS wishes to place a child in extended society care for adoption and there is an access order in effect, it will serve every person who has been granted a right of access and every person with respect to whom access has been granted with a notice of intention to place for adoption. When this notice is served, the person who has been granted an access order, an access holder, has the right to apply for an openness order within 30 days after notice is received. SS 195, 2, and 196, 1. A person with respect to whom an access order has been granted has no right to apply for an openness order. Whether a person is an access holder has therefore become an increasingly important consideration when trying to maintain contact with a child or sibling post-adoption. An openness order may be made if the order is in the best interests of the child. The order will permit the continuation of a relationship with a person that is beneficial and meaningful to the child, and the child has consented to the order. If the child is 12 years of age or older, S196, 7. In deciding whether to make an openness order, the court shall consider the ability of the prospective adoptive parent to comply with the arrangement under the openness order. S196, 8. The best interests test under this part is set out in S179, 2. In the CYFSA, there are requirements for CASs when they are planning for an adoption of a First Nations, Inuk, or Métis child. A CAS will be required to consider the importance of developing or maintaining the child's connection to the child's bands and First Nations, Inuit, or Métis Communities S187. 1. In addition, under the CYFSA, there is a new type of openness order permitted where a CAS intends to place a First Nations, Inuk, or Métis child for adoption. When a CAS begins planning for the adoption of a First Nations, Inuk, or Métis child, the CAS will be required to provide notice of its intention to a representative chosen by each of the child's bands and First Nations, Inuit, or Métis communities. S186. 1. The notice will also advise that the CAS, child, or representative has the right to apply for an openness order within 30 days. SS 197. 3. N. 5. 2.15 Appeals Section 121 of the CYFSA and R38 of the rules govern appeals of orders made in child protection proceedings, with the exception of orders relating to assessments, from which no appeal lies. Any order made in a child protection application may be appealed as of right. A notice of appeal must be served within 30 days of the granting of the order. No extension of the time for an appeal can be granted where the child has been placed for adoption. S121. 5. If a party appeals an order regarding care and custody of a child, S121. 3. Provides for a stay of execution of the order for 10 days following service of the notice of appeal to allow the appellant to seek a temporary order from the appellate court. Subsection 121. 6. Allows the appellate court to receive evidence relating to events that occur after the order being appealed was made. 2.16 Status Review Applications. Sections 113 and 115 govern status review applications. As the name implies, a status review application is a request by an interested party that the court review a child's status. Under S113, a status review application can only be made if a child is the subject of an order for society supervision or interim society care under S101. Pursuant to S114, at the hearing of a status review application, the court may vary or terminate the original order made under S101 or make a different order under S101 or 102. In the case of supervision orders and interim society care orders, which are imposed for specified periods of time, a status review application must be commenced prior to the expiry of the existing order, failing which the original order lapses. If the child has been placed in extended society care or has formerly been in extended society care, the status review is brought pursuant to S115 of the CYFSA. If a status review is made pursuant to S115, the court may make an order pursuant to S116 of the CYFSA. A CAS may apply to the court at any time for a status review unless a child has been placed in a person's home for the purpose of adoption and continues to reside in that home. If any other party wishes to commence a status review application, the party must wait until 6 months have elapsed from either the date of the S101 or S116 order or the date of the final disposition of an appeal from that order, whichever is later, unless the court is satisfied that a major element of the plan for the child is not being carried out. SS 113, 6, 7, and 115, 7, 8, other than a CAS, pursuant to SS 113, 4, and 115, 4, the parties permitted to apply for a status review are the child, if the child is at least 12 years old, a parent of the child, the person with whom a child was placed under an order for society supervision, and if the child is First Nations, Inuk, or Métis, a representative chosen by each of the child's bands and First Nations, Inuit, or Métis communities. If the child is in extended society care and a status review is sought pursuant to S115 of the CYFSA, the following additional persons are permitted to apply for a status review. S115. 4. The person to whom custody of the child was granted. If the child is subject to an order for custody under S116. 1. B. And a foster parent, if the child has lived continuously with the foster parent for at least 2 years immediately before the application. If the child is in extended society care and has lived with the same foster parent or the same person under a custody order continuously for 2 years, the child's parent may not commence a status review application without leave of the court. S115. 5. 2.17 Statements of agreed facts. The majority of child protection proceedings are ultimately resolved by consent of the parties. The court is not bound to make the order to which the parties have agreed. It must consider the evidence and determine whether the requisite tests have been met and whether the order requested is in the best interests of the child. In many Although not all jurisdictions in Ontario the parties' consent is provided through a statement of agreed facts. There is no statutory provision for such a document. However, there are prescribed forms in the rules. R33.7. Form 33C is the Statement of Agreed Facts for Child Protection Applications. It is designed to ensure that the court has the necessary information to determine that a child is in need of protection, that a court order is needed to protect the child, and that the disposition is in the child's best interest. The required information includes statutory findings about the child, name, birth date, parentage, First Nations, Inuit, or Métis status, and the place from which the child was removed and brought to a place of safety. Information about the history of CAS involvement with the family, reasons the child was brought to a place of safety, basis for finding the need of protection, the relevant clause in S74.2, and supporting facts, significant events since the protection application was commenced, and order, S, agreed upon, including any conditions and access terms. The Statement of Agreed Facts for a Status Review application is Form 33D. It is intended to provide the information necessary for the court to determine what, if any, continuing order would be in the child's best interests upon the expiry of the previous order. This information includes relevant events that have occurred since the making of the last order, and order, S, agreed upon, including any conditions and access terms. In reviewing these documents with the client, it is essential to keep in mind that the facts agreed to will be treated as admissions made by the client. Very often these documents are produced by the CAS at the 11th hour and consist largely of a cut and paste of their application or affidavit. Parents and counsel may be more focused upon the bottom line, i.e., the actual order being agreed to, rather than on the details set out in the recitation of facts. Ignoring the facts and details in a statement of agreed facts is dangerous because those facts may be relied upon in cross-examination or in future proceedings against the client. For example, a parent should not agree to having had a drug dependency where there is only evidence of drug use during a specified period of time. Counsel for parents must be careful when reviewing the statement of agreed facts with clients. Generally speaking, it is in the parent's interests to agree to the minimum history required to underpin the order being asked for. It is often preferable for parents' counsel to take the initiative to draft the statement to ensure that it poses as little future prejudice to the client as possible. Notwithstanding this, the CAS is free to prove any other evidence outside the statement of agreed facts despite what was signed and counsel's efforts to limit the evidence at a future proceeding. 2.18 Plans of care. The CAS is required to provide a written plan of care for any child brought before the court. S100. That plan must include a description of the services to be provided to remedy the condition or situation on the basis of which the child was found to be in need of protection, a statement of the criteria by which the society will determine when its care or supervision is no longer required, an estimate of the time required to achieve the purpose of the society's intervention, where the society proposes to remove or has removed the child from a person's care, an explanation of why the child cannot be adequately protected while in the person's care, a description of past efforts to do so, and a statement of what efforts, if any, are planned to maintain the child's contact with the person, where the society proposes to remove or has removed the child from a person's care permanently, a description of the arrangements made or being made for the child's long-term stable placement, and a description of the arrangements made or being made to recognize the importance of the child's culture and to preserve the child's heritage, traditions, and identity. In contrast to the statement of agreed facts, it is generally in the parent's interest to request as much detail as possible in the CAS plan of care. A failure by the CAS to carry out a major element of the plan may enable a parent to bring the matter back for an early status review. S113.7 and 115.8. So if, for example, the CAS has identified the child's unaddressed treatment needs to be the essential problem, it's best to require the CAS to spell out what treatment it intends to provide. The CAS plan can be pivotal to the parent's case on a status review application. If part of the plan was to ensure frequent and regular contact with family members, in recognition of its importance to the child's interests, and instead of doing so the CAS promptly placed the child at a distance that precludes such contact, there may be a basis to review the Order. 2.19 Priority of child protection proceeding over custody disputes. A child protection proceeding is normally treated as paramount to a custody dispute even if the child protection proceeding is in the Ontario Court of Justice and the custody dispute is being litigated in the Superior Court of Justice. Similarly, a private custody order will be superseded by an order made under the CYFSA if the two orders are inconsistent. Section 103 of the CYFSA provides that where a proceeding is commenced under Part 5, any proceeding respecting custody of or access to the same child under the CLRA is stayed. If a CAS has been involved with the family and the parents subsequently have a custody or access dispute, the CAS file may be relevant. The CAS will not release a file without the consent of all parties or a court order. If one of the parties withholds consent, the opposing party may bring a motion pursuant to R19:11 for production of the CAS file. The motion must be brought on notice to the CAS. The CAS may, however, upon request provide a written summary of its involvement with the family, blacking out any reference to a person whose consent to disclosure has been withheld. 3. Personal information. CYFSA. Part 10. Although CASs regularly obtain personal information about individuals involved with their services, the CFSA did not legislate how this information was collected, used, and disclosed, except in very limited circumstances. Part 10 of the CYFSA came into force on January 1, 2020, and sets out extensive rules respecting the collection, use, maintenance, and disclosure of personal information by service providers. It also sets out an individual's right of access to the records of the individual service providers. The new part is modeled on provisions in the Personal Health Information Protection Act, 2004, and complaints regarding contraventions of this part can be made to the Information and Privacy Commissioner S. 316. 4. An Act respecting First Nations, Inuit and Métis children, youth and families on January 1, 2020. An Act respecting First Nations, Inuit and Métis children, youth and families (FNMCF) came into force. This is federal child welfare legislation that sets out three main purposes: to affirm the inherent right of self-government for Indigenous people, which includes jurisdiction over child and family services; to set out national principles regarding the provision of child and family services for Indigenous children; and to contribute to the implementation of Canada's obligations under the United Nations Declaration on the Rights of Indigenous Peoples. FNMCF sets out a process for an Indigenous group, community, or peoples to exercise its legislative authority in relation to child and family services. It also sets out a different legal test for the best interests of an Indigenous child, the way that child and family services should be provided to Indigenous families, and the priority of placement of an Indigenous child. 4.1 Conflict of laws. Although FNMCF recognizes the right to Indigenous self-government, the legislation also clearly states that the Charter applies to an Indigenous governing body in the exercise of jurisdiction related to child and family services on behalf of an Indigenous group, community, or people. Child protection is typically within provincial jurisdiction, and each province has its own child welfare legislation. FNMCF states that nothing in FNMCF affects the application of a provincial act or regulation to the extent that the provision does not conflict with, or is not inconsistent with, the provisions of FNMCF. It is yet to be determined how the federal paramountcy of FNMCF will play out in the day-to-day implementation of the CYFSA and other provincial child welfare legislation. FNMCF also addresses the issue of conflict of laws between Indigenous laws respecting the provision of child and family services and federal and provincial legislation. If there is a conflict or inconsistency, the Indigenous law prevails to the extent of the inconsistency, except if it would not be in the best interests of the child. FNMCF also sets out a process if there is a conflict or inconsistency between the laws of two different Indigenous groups, communities, or peoples. Chapter 63 Aboriginal Law in a Family Law Context. 1. Introduction. As a general rule, family and child protection laws that apply to individuals in Ontario also apply to Indigenous people in the same way. However, there are some very important exceptions that must be noted. As a preliminary matter, the practitioner should be aware of the impact of self-governance on Indigenous communities. Some First Nations have enacted their own laws, through inherent jurisdiction, self-government agreements, or by lawmaking authority under the Indian Act, that may displace provincial legislation in Ontario too. Marriage. Canadian courts have upheld customary laws on marriage and adoption even in the face of legislation that might be taken to have abridged such laws. For example, the validity of a marriage under Cree customary law between a non-Indigenous man and a First Nations woman was upheld. As well, In another case, it was held that the customary wife of a man accused of a crime may refuse to testify against the man based upon spousal